लिख देते हैं।
Compelling circumstances, my lord, in my mother's side is present, my lord, is a part of motions, my lord, that the agreement will be executed on Friday, my lord, day after tomorrow. So, my lord, extreme urgency is there, my lord, because, my lord,
appearing in the list.
Yes, my lord.
Item?
Item part had 74. 70? 76. Friday, my lord, that the agreement will be executed, which has been challenged, my lord.
My lord, last date for execution of the agreement.
Very little appear to tomorrow, then 10:30.
Tomorrow is holiday, possibly.
Day after tomorrow, 10:30.
Get it.
Friday.
I'm grateful to you.
May I have your lordship kind leave to mention a matter for leave to obtain a tender number?
Instead of 10:30, my lord, can we not 12 only?
No. 10:30. Yes.
Leave to obtain a tender number for two matters. My lord, Southeastern Railway, tender floated, connected work. Rejection on Saturday. I'm communicated the reasons on Monday verbally. Wednesday before your lordship. In a minute, rejection. A minute after that, techno-commercial bids opened. By Friday, they'll award it. One of the bigger indulgences, this is an uninformed copy. Lordship will allow me to come back at 2 o'clock today. I'll just show, my lord, fair enough, my lord, on Friday then.
Friday.
Could I just get the leave to obtain the tender
Yes,
number, my lord,
yes,
and then
yes.
My lord, similar prayer, leave to obtain tender number
Same
and
answer.
a form.
Same answer. Leave is granted.
But my lord, in my case, there is an urgency, my lord. My bank guarantee is being sought
So
to be.
Friday.
My lord, sought to be invoked. Tomorrow is a holiday, my lord.
No, today it cannot be done.
My lord, may I have a
My-
kind leave to mention a matter,
Writ-
my lord? The writ petition of appearing 382, my lord. The writ petition becomes infructuous because they have already encashed a debit note, my lord. One has been encashed, one is left, my lord. If my lord can take some urgency, my lord. But please, my lord.
No, no.
My lord, that I humble prayer, can I take it, my lord? Can they release this matter, my lord? The
Yes, yes. Which one?
382, my lord, monthly list.
382. I'll take up at 2. Inform you. Your other side is here now.
There-
Inform your other side.
There's no other side. No, nobody is appearing on the other side. It has not been taken up once also.
Well, this is item
382
382
of the monthly list, my lord.
on the prayer of the petitioner for urgent for upgradation of the matter, comma, the matter is taken up for hearing, full stop. However, comma, since there are more urgent matters on the list, comma, on the prayer of learned counsel for the petitioner, comma, the matter is released from my list with liberty to the petitioner to pray for assignment before an appropriate bench.
Grateful.
My lord, under compelling.
এই যে সইটা আগে করিয়ে নেবেন। Yes.
Item number 42, my lord, I am praying for leave to withdraw, my lord, because it has become infructuous.
It will be taken in due course. Yes.
Under compelling circumstances, I'm mentioning a matter, your lordship. The bank guarantee had been invoked by the respondent. They had taken away the money, your lordship. Now my creditors are at my throats and
If they were to take away, they have taken away.
no, your
So
lordship, they have done it illegally, your lordship.
no, 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 no.
Your
not
lordship
this.
had by a previous.
No, I'm sorry. No. Yes.
Urgent circumstances, my lord, I am praying for your lordship's kind leave, my lord, to file this, to hear this for hearing of this matter in an unlisted manner, my lord, because there is a urgency, my lord. My lord, today the respondent authority will be drawing up the connection to the property of the private respondent, and the drawing of the connection will be over my property, my lord. The where will we go with
This is not such a.
over my property, my lord?
No, no. Let it go. Yes. Yes, Mr. Chakur.
Lord, I have earlier not traveled your lordship with this Lord. Lord, I know
Please
Lord,
be up. Please faster. I'll have to take up so many matters.
Lord,
Yes.
what happened is Lord, without any proceeding, without any hearing, Lord, a running concern has been banned by the authorities, Lord, and they have issued a completion certificate with the banning order where they have mentioned the banning, so I cannot use that anywhere.
No, Mr.
Lord,
Chakur.
Lord, absolute violation of
No.
natural
Yes.
justice.
And I mentioned one matter. It is a jurisdiction of my lord, Mr. Motion Bhattacharya, my lord, audience matter. My entry order expired on the 30th, my lord. Your lordship.
Hand over for extension on Friday.
My lord,
My lord, may I be permitted to mention a matter? My lord,
Audience set যারা আছে তাদের দিদি yes. রেখে দাও। Yes.
My lord, the matter is running on item number 217 on daily list. There is urgency in this matter. It's for upgradation.
What is urgency?
The urgency is the district magistrate, the executive district magistrate was given order through this court, but and it has to be implemented within a week, but it's not implemented, neither the copy is served.
Sorry, no. Yes.
My lord, what should mention a matter, my lord? It is the electricity matter. After getting the petition and notice, they have disconnected. They are the leader of Panchayat.
Let us wait for some time for this matter.
Item number 22, my.
No, not, no urgency.
Very urgency.
No upgradation, I'm sorry. Yes,
my
lord. I said no.
My lord, I have come here under a compelling and very urgent
What is that,
situation, my
please?
lord. The medical council, which is running, it's an unlawful body. This
What is the urgency, Dr. Shah?
because it was constructed, it's an unlawful body, and every day,
It's not an urgency.
my lord, they are giving decisions on negligence.
Oh,
My lord,
much more urgent matters are waiting in the
my
list.
lord,
No, Dr. Shah, no upgradation. I'm sorry. Call on the list. Yes, call on the list.
Port Blair matter, item number 1.
Yes. What is the application for? Application is not appearing.
Maharaj, this is a contempt application.
Acha.
Maharaj, this is a contempt application. Basically, Maharaj, I am appearing on led by Mr. Shatadru Chakrabarti and he is led by Mr. Mr. Gopala Vinu Kumar. They both are on their legs before the division bench. It is going on because Maharaj, this matter is in this matter we have made an appeal from the final order and that appeal is listed today. So, my lord, I am praying an accommodation to kindly be this matter be adjourned, my lord, unless the appeal may be heard, my lord, or in the month of August, maybe, my lord.
Month of August, very well. None appears for the petitioner at the time of call. Full stop.
My lord, petitioner is present, my lord. Petitioner is present.
Very well. None appears. At the outset, it is prayed by learned counsel for the alleged contemner that the matter may be adjourned till August 2023, since an appeal against the parent order is at present sub judice before the concerned division bench. Full stop. Hence, let the matter stand adjourned and shall next be listed on August 8, 2023.
Grateful, your Lordship.
August 8, if the regular bench is sitting there, there will be a circuit then. Oh, no, this is the contempt. I'm sorry. August 8. Right. ডাকতে থাকো তুমি পরেরটা হাতে রেডি রাখো না কেন?
To be mentioned, item number 1 for non-prosecution.
Yes.
My lord, I'm here on behalf of the petitioner. My lord, I have instruction to not press. My lord, I have.
Learned counsel for the petitioner submits that the petitioner does not want to proceed any further with the matter. Full stop. Accordingly, WPA 19959 of 2021 along with CAN 1 of 2022 are dismissed for non-prosecution without any order as to cost. The written instruction filed today be kept on record.
Grateful.
Thanks. Next.
Item 2.
I beg to appear for the bank.
Yes. Yes, Mr.
No, my lord, your lordship had concluded the hearing.
Right.
My lord, this is, my lord, that my lord, deplaning, deboarding matter. My lord,
Deplaning, yes. Yes, anything else?
Now, my lord, it was kept today only, my lord, for the immigration authorities to take instructions.
Yes.
Whether, my lord, that my lord, document which was handed up, my lord, by the bank was an authentic document.
Mr. Tiwari is appearing for the Bureau of Immigration. He was here.
He was here. He told me that, my lord, his client didn't pick up his telephone call.
Yes, I picked up your telephone call. Answer me. Is that actually there? I mean, is it?
I have understood what I have understood after going through this circular.
Yes.
That was issued on 21st May 2022.
Right.
And Millard, that was valid for a year. So it was an intimation to the bank, wherein Millard, it was stated. It was stated that this LOC shall remain in force until and unless a deletion request is
Yes,
received.
then this is authentic.
So, Millard, that means within the period of 1 year, if
Has to be read like that.
yes, Millard. Within the year, 1 year, Millard, if any deletion request is Millard received from the bank, then Millard, we shall be constrained to Millard.
No request for deletion.
So I'll close arguments. I'll record this and close arguments. Learned counsel appearing for the immigration authorities submits that the intimation dated May 21, 2021 is authentic. Full stop. However, the same has to be read in the context of the law to the effect that the LOC shall remain in force until and unless a deletion request is received by the BOI from the original itself, comma, which has to come within the statutory period of 1 year. Full stop.
30th of May 2023.
Taking note of such submission, comma, since arguments have already been concluded, the hearing of the matter is closed. Full stop. The matter is reserved for judgment. I'll try to be as quick as possible so that your client, if I allow, they can leave. Otherwise, they'll know their fate.
According to me, the Milord, LOC is Milord, valid till 30th of May, Milord.
30th of May.
Yes, Milord. As per my
আচ্ছা আরেকটা লাইন অ্যাড করে দিন ওই শেষের আগে
20th of May, Milord. Sorry, 20th of May 2023. As per my affidavit.
It is further submitted by the immigration department that the LOC is lastly valid till May 20, 2023. Thank you.
Your Lordship is not inviting any comments from us, Milord, sir. Because Milord, your Lordship had yourself pointed out that Milord, the document itself provides that Milord, this LOC shall remain in force until and unless the deletion request received from the BOI is received from the BOI or from the originator itself.
Immigration authorities has made it stand clear, and they have also clarified that it was till May 20th.
Yes, but Milord, whether Milord that
I'll give a
the
one-line
deletion-
order probably. It has become
the deletion, Milord, unless it takes effect. Milord, I'll
yes, that creates some doubt.
it does, Milord. I
does,
can't,
it
Milord.
does.
This is and the humiliation that Milord one has to undergo to Milord
Right.
get up on a
That is
flight and
also
then
there.
be hauled down from that.
That is
So,
also
Milord,
there.
this is
Good. Thank you.
grateful.
বিশুকে ডেকে পাঠিয়ে একটা চাবুক আমাকে দাও তাহলে চাবুক দিও না শুধু ডেকে পাঠিও না বলো ফোন করে বলে দাও যে এটা হচ্ছে না বলে দিয়েছো তো
Item 3.
This matter, my lord, the address of the some of the respondents, rather the principal respondent wrongly furnished. It will create some
you are petitioner you are for the petitioner
The petitioner, I want to withdraw with the liberty to file application for the.
acha learned counsel for the petitioner submits that the petitioner seeks to withdraw the writ petition with liberty to sue afresh comma in view of technical errors in the writ petition full stop such prayer is granted stop accordingly WPA 13722 of 2023 is dismissed as withdrawn with liberty to the petitioner to file a fresh writ petition on the self same cause of action no rest to court.
I'm for the WBSCL.
Right.
Top item 4.
Top ছিল না।
I appear for the petitioner, your lordships.
যেটা ডাকলে এটা টপ 4
Item number 3.
এইখানে টপটা নিচে লিখে আছে
Milord,
Yes.
item number 3, I was appearing for the state respondents, Milord.
please give a name please
Wait for it.
item number 3 তে মাধববাবু ঢুকে নেবেন আগেরটায় শোনা না 4 yes you are appearing
But I appear for the petitioners, my lord. There are 4 petitioners before your lordships today, my lord. These petitioners all are from Myanmar, my lord. They used to reside in Myanmar.
Rohingya allegation of
Rohingya.
Rohingya
Yes.
you want deportation or what do you want
I entered India. I was arrested and was tried for violation of 14A of Foreigners Act, and then my lord sentenced to imprisonment. I have served my term. Thereafter, my lord, almost now,
maximum sentence you have served
yes, and thereafter 4 years have passed. I am still in jail.
still in jail
Yes,
why
still in jail because my lord, they say that I am to be deported. That was initially because I was my deportation was being contemplated, my lord.
you are major
Yes,
not
yes.
minors
Not minors. My minor children or our minor children are also there in India. They are kept in homes. They were never incarcerated. They were kept in homes. They are still there. I am given to believe, my lord.
so what is
And-
your prayer now deportation then
No.
Released from jail.
I fear for my life because if I am deported, my prayer is not to be deported. Rather, I pray that I be.
that the court cannot grant it's very difficult humanitarian grounds you are absolutely right we know the situation there but the difficulty is can a court of law direct preempt that right of the government if you are deported then we can probably in certain circumstances interfere but
Yes.
before you are deported can we interdict that is the prerogative
No,
of
my
the government
Yes.
despite Mr. Trivedi appearing for the government.
Yes.
Is their prerogative.
My lord, during the hearing of this application before the other honorable judge of this honorable court, my lord, there is already a my lord order whereby it has been said that it will not be deported right now, my lord, during
That was an
pendency of the
interim
petition,
order.
interim order, yes. And my lord, I say, my lord, that
Interim order definitely could not have been deported because it was sub judice.
of course, of course. So, my lord, I say that not only I probably will not be deported, I say that I will not be kept in custody. Even if my deportation is being contemplated, then also I will not
want to be kept
in any
The
safe
Raj Bhavan.
in any safe home outside
Safe home is more risky for him. It is not safe at all. Safe home in the state.
in anywhere in India.
My lord, they are saying that they should be given citizenship.
Huh? No, no.
My lord, the whole argument, my lord, I am not speaking from the cuff.
They
my
cannot
lord.
say that.
My lord will kindly see they are saying that there is a policy which we have wherein we will be allowed, they will be allowed to stay in India under one particular permit given by Ministry of External Affairs and
Mr.
Home
Trivedi, the
Department.
difficulty is Rohingyas are being persecuted. That is common knowledge. Now the difficulty is you are sending them means you are sending them to the butcher house.
My lord, we are,
They prefer this butcher house better than that.
my lord, butcher house or no butcher house, my lord, we are not going to go into that particular controversy, my lord. There are certain policies which we have made, my lord.
Like, yes.
And my lord, there's the Honorable Supreme Court's judgment also on this particular issue when this issue was raised before the Honorable Supreme Court.
Right.
And the
It's an
Honorable
entirely humanitarian ground now.
Now the
But
Honorable Supreme
release from the jail definitely will consider because they have already served the sentence.
Well, released from the jail, my lord, they are in safe homes, my lord.
They are in safe homes.
Yes.
No, no, no.
Their allegation is there in
Definitely
prisons.
not.
My lord, they are in safe homes. You know, the state is not being represented. Why I am for the Ministry of External
Yes, yes.
Affairs and Ministry of Home Affairs. My lord.
Right,
The state are the authorities who are keeping them, and they have created safe home. And in their affidavit, a report on affidavit which was submitted, which is forms part of the record of my lord, they have specifically and categorically stated that they are not in custody, but they are in safe home in the vicinity of Damdam area, and that is on record.
Pointed this out. You should have pointed this out. This was filed in court previously.
Their case is that a cell converted
You
into a
should have
safe.
pointed this out. We should look into this.
My lord, I will kindly see the I'm
Lord,
just
it's
pointing
report.
out, my
I've
lord,
got the
they have
report.
filed an affidavit, a report in form of an affidavit has
right.
been filed by the
Para number 8 of state's affidavit.
And my lord, there is a procedure, my lord, where their identity and the अच्छा, वो कुछ चलो। Thank you. My lord, will kindly see.
Lord, if your lordship takes up the affidavit filed by the state, the report filed by the state at page 4, paragraph 3-4.
Yes.
Lord, towards the bottom of that paragraph, in the instant case, all the 4 petitioners have been provided an accommodation in a temporary camp or safe home within the premises of Damdam Central Correctional Home. The entire process has mentioned, Lord, this goes on. Now, I say that this is not a safe home at all. This is a portion of the prison. It is a cell, in fact, which has now been just renamed as safe home. It is not a safe home. I am being kept behind bars. And my lord, this not only, my lord, contradicts the Honorable Supreme Court judgment, my lord, which says that I must be kept outside prison in a safe home. This also, my lord, flies in the face of the government's own, my lord, guidelines and policies which they have presented before the court, which says that following that Honorable Supreme Court's judgment, they must not be kept inside prison, but the safe home should be situated outside the prison.
What is that?
Yes.
That's also part of the report.
Yes.
Mr. Trivedi, please take your seat. I'll just hear him first.
Milord, if Milord takes up the
What
same affidavit.
What I'm humbly submitting, my lord.
Yes.
The state government will be the right person, my lord, who is representing.
That's why I'm asking you to take your seat.
My lord, I apologize.
You are not concerned with this, actually.
My lord, I am
safe home. You are not concerned.
My lord, I am concerned because, my lord, we are concerned, my lord, because
till they are deported, at least they have to be in a safe home.
Yes, my lord. We are saying, and we have been informed that they are in safe home, my lord. Now
that information does not seem to be correct. So the state has to answer for
my
that.
lord.
Let us wait for the state for the time being. Yes. Yes, where is that?
Yes, my lord.
Their rules.
Yes. My lord, may I take your
Take me
lordship
directed to that rule where it says it cannot be within the prison
a
presence.
part of the
May I
rule, page
take leave
20.
for 1 minute, my lord?
Yes, yes.
Page 20 of the same affidavit
Page
filed
20,
by the
right,
state,
right,
report
right.
filed by the state.
Which para?
My lord, the last paragraph 6.2.
Right.
Subsequently, in pursuance of the orders of the
ডাকতে
honorable.
বলিনি তো হ্যাঁ। My lord, ডাকতে বলিনি তাহলে কি করবো হ্যাঁ দেখুন তখন সরি
Yes, my lord.
which clause
6.2, the bottom of
right, right, right.
Subsequently, in pursuance of the orders of the Honorable Supreme Court of India dated so and so in Bhim Singh versus Union of India and others, the ministry had reiterated the earlier instructions dated 2/7/1998 to state governments or UT administrators for strict compliance with a letter number so and so dated 7
Outside
March
jail
2000.
premises, seen it, yes.
Yes.
Very well. So
The
as per
release
this,
from-
they right.
And my lord, at page 21, and they may be kept at appropriate place outside the jail
I've seen
premises.
that, I've seen that, yes. No, they have not complied then.
No.
You are for? He's with you?
No, no.
My lord, I'm for
Probably-
the state, my lord. I'll-
Yes, Mr.
No, no, my lord, may I indicate, my lord, kindly take, my lord, the order of our division bench. My lord, which is, my lord,
Probably
Part of the
Justice
annexure
Indira Banerjee, September 2014. Oh, acha, हाँ, it has been annexed, sir.
that's what I'm saying.
Next.
Yes, it is annexed to your report. Page 10 of that probably, Mr. Mukherjee.
Yes, my lord. My lord, kindly see, my lord, page 9, my lord.
Yes,
Last paragraph. My
Right.
lord, this is, my lord, the division bench order. In the present case, Fatima is a foreign national. She has served out the sentence in so and so. There's a pending writ petition filed, which she has described herself, whereas present writ petition, etc. There is thus an apparent dispute, etc. Fatima is not under illegal detention. She has been provided accommodation in a building within the premises. Steps have already been taken by the state for accommodating all foreign released inmates of all in a safe home at Jointipur under jurisdiction petitioner reserve. And that, my lord, home is being set up. My lord, this is an interim arrangement.
steps are being taken on July 12th,
Yes.
last year. So we
Yes.
have, we're 1 year past that. So what
happened,
steps?
my lord?
They're still in the jail premises.
Yes, my lord, but they are not under law, my lord.
No, even then, Mr. Mukherjee, they cannot be within the jail premises, within the jail compound, because your circular says,
It's not our circular, it's central government,
Acha.
central government.
But you are bound by that.
Yes, yes, my lord.
There's
my
the jail authorities, yes.
Yes, my lord, we have to, my lord, between
Comply,
state
yes.
and center, my lord, otherwise I would have loved to argue this matter on behalf of the petitioners. My lord, but I can't.
True, that's true, that's true.
But I can't. My lord, that's,
Yes.
my lord, the problem.
So appropriate place outside the jail premises.
Kindly give us some time, we'll have.
Mr. Mukherjee, I'll then direct the state to file another report projecting their whatever they have done already. I'll give you some time to place them in appropriate place. So what will be a reasonable time? I'll give you 3 weeks, Mr. Mukherjee. 3
Because, my
weeks.
lord, I'll tell your lordships, my lord, several other states, my lord, have camps. My lord, but my lord, those are, my lord, even worse.
Those are worse.
So, my lord,
We are reading every day, Mr. Mukherjee, although that we cannot base our knowledge on that in court. But even then we know the camps. So you have said, since you have said that there are Jayanti somewhere in Jayantipur, Mauza.
Yes, my lord, will.
So please set that up and
I'll check that up and.
thank you so
My
much.
lord,
I'll just record that.
Yes, my lord. Detention is not, my lord, something, my lord, which we are, because, my lord, my personal view is, my lord, they're actually stateless. And, my lord, under customary international law, my lord, we
Yes.
should not, we should follow the principle, my lord, of applying Article 21 to them. That's my personal view.
Absolutely,
The
Mr.
Supreme
Mukherjee.
Court now, my lord, has kept the matter pending and refused to grant interim order.
We shall have to wait for some further appointments probably of judges
My lord,
for that
yes,
to
for
take
the
place,
decisions to be
for the
taken.
decisions to come. Learned counsel for the petitioner argues that despite the governing regulations of the Ministry of Home Affairs, Government of India, stipulating that after expiry of the term of sentence, comma, people of foreign nationalities, comma, till they are deported, stroke repatriated, comma, have to be placed outside jail premises in safe homes, comma, the present petitioners, comma, similarly circumstanced as the circular, comma, are still within the precincts of the Damdam Central Correctional Home. First up, it is submitted that such detention of the petitioners within the jail premises is patently contrary to the government circular. First up, next para, the learned advocate general appearing for the state submits that the petitioners have not been kept within confined cells, but have been placed within the jail premises, comma, outside such cells. First up, next para. However, comma, it is further submitted that as submitted before a division bench in a different matter, comma, the government is taking immediate steps for setting up a safe home at Jayantipur Mauza under the jurisdiction of Bongaon Police Station. First up, next para, upon a perusal of the division bench orders cited in the report filed by the state government, dated July 12, 2022, comma, it is evident that even on that date, comma, a similar submission had been made on behalf of the state. First up, next para, however, comma, the learned advocate general assures that he will take steps to impress upon the state so that the petitioners are placed in some safe home at the earliest. First up, next para, accordingly, the matter is adjourned till July 24, 2023, when it will be listed fairly at the top of the list. First up, the state government shall file a report on the next returnable date, indicating as to what steps have been taken for shifting the present petitioners to a suitable safe home, comma, which is habitable within the contemplation of Article 21 of the Constitution of India. First up, next para, it is expected that such shifting shall be done in the meantime, comma, either to the safe home to come up at Jayantipur Mauza or elsewhere. First up, this much. Thank you.
Milord, just in order to Milord aid the Honorable, the learned Advocate General Milord, I had been able to lay my hands on some judgments of this Honorable Court, whereby names of some safe home probably have been indicated. May I just hand them
So
over?
that you can hand up to Mr. Mukherjee's office.
Yes.
I mean,
And just one Milord, policy of the state which says that if immediately safe homes are not available, under that policy itself, the guidelines itself, it has been said that the state will have to rent some place to make them stay over there if it is not constructed yet.
I'll finally decide on this point, at least on the next date.
Yes.
So
So I'll in the meantime hand over everything.
Yes.
Yes.
I'm grateful. Thank you, sir.
Item 5.
Yes.
May I appear for the petitioner?
Yes, sir.
May the writ petition is for, my lord, payment for work done. Where on the last occasion, my lord, the work is completed, no dispute on that. Long due, they certify that it was done at a war footing basis, etc. And my lord, now, my lord, certain payments are due according to us 3.17 crore. Now, the last day, my lord, the exact figure is 3 crore 17 lakhs 17,578.
578?
On the last occasion where my learned friends wanted to take written instructions.
Yes, yes.
That is on 21st of this.
Right. 21st
Yes,
of June.
21st. 22nd, my lord, we receive a letter from them. If I may hand up, my lord, I don't think my learned friends would.
No.
Yes. But on 22nd, we receive a letter that the actual amount is 2 crore 61 lakhs. Please take the last paragraph.
Yes.
Instead of 3 crore 17 lakhs. My client is suffering, so they gave a letter saying that, okay, we are agreeable to this amount. And if this is immediately released, this is one condition. The other is, this is without prejudice to our other rights.
আর একটু খেয়াল রাখো কি হচ্ছে।
May I have taken instruction, my lord. A similar matter was moved before
last page of this.
Honorable Justice Bhattacharya. Last page of the application, writ petition. But the only distinction is that in that case,
yes,
the petitioner had made a representation before the state government. I tell you, Lordship, the fact is like that. The payments are to be made by the state government. These are. Oh, this is the order. I'm so sorry. এটা কিসে লাগিয়েছো? I'm sorry.
last page annex করে দিয়েছি।
আরে না না। Kindly take, my lord, this order.
Yes.
Your lordship will find the direction is upon the state government to release the funds within a certain period, and immediately thereafter we would release this amount in favor of the petitioner. So, my lord, I am praying with your lordship that identical order may be passed in this case. I think, madam, Mr.
But may I
Dotto,
then take this indulgence, my lord? Kindly permit me to also, in future, if my client so desires, because he's out of pocket with so much amount, my lord.
So make
There's the
further
other claims
since this is the admitted
this is-
amount, I'll direct them to.
only, my lord, if your lordship.
Full and final settlement.
But these are full and final settlement.
No, full and final settlement, then it cannot be.
True, but see the last sentence.
আবার কি হতে পারে?
Immediately, my lord, we will.
Without prejudice
So
to
I'll
our
also
other
put
rights.
that in my order. Yes. No, without prejudice is not there in Justice
Last,
Bhattacharya.
last.
No, my lord, before, in the other matter, this kind of exchange was
It
not
was
made.
not there.
They responded to our letter. In their response, they indicated that they are ready to accept 2 crores 61
Without
lakhs.
prejudice to their other rights and conditions.
What
Shall
is
keep
the-
that open. Then it cannot
The
be for
only
full
one
and
thing,
final
if
settlement.
your lordship can- if your lordship takes the order passed in the other matter, kindly take the page 2. Page 2. And I believe, my lord, Mr. Doctor would be
Yes.
Third paragraph.
third paragraph at page 2. Learned counsel appearing for petitioners submits an instruction that the petitioners are willing to forego the claim
For the
of
time
interest
being.
for the time being. The identical order may be, I think this
I'll
is
send
the-
this matter also, the previous matter also to Justice Bhattacharya's court, and I'll record an order that this may be modified. For modification, this may be placed before the other court also. Because Justice Bhattacharya has recorded this to forego the claim, but this was missed out in the ordering portion. So I'll record my observations and send it to
whatever, but identical directions may be issued. my lord.
up to penultimate paragraph identical.
Penalty-
Last paragraph. The last paragraph, there will be one change. Without
one
because they are not willing to forego the claim for interest forever. I mean,
No, this is also indicates that they are not foregoing
for the
claim
time being.
For the
For the
time.
time.
It is identical, my lord.
No, my language, I'll paraphrase.
Very well.
We usually paraphrase, but we should not say that. I am candid enough to say that. Learned,
May I
should
take
I
your-
refer to this order also? But there will be a deviation from this. I'll have to record my disease.
Yes, need not.
I
My
think
lord, first, directions are to be given to this respond number 1.
Yes, yes,
They
very.
have to issue.
But that direction,
The-
was
in- yes,
on
yes.
that, my lord, if the,
That portion definitely I'll have to
Yes.
take from.
Shorter nature.
but only one thing, but the state may be directed to expedite the release of the money.
Immediately, yes, yes. That was also done in the previous act order.
May I take your lordship's kindly?
Yes, yes, yes.
বুধবার দিন তো তোমার সকালে তো অনেক আছে।
It is submitted by learned senior counsel appearing for the petitioner that the amount due to the petitioner upon the completion of work is to the tune of rupees 3,17,17,57 full stop next para. However, learned senior counsel also points out that in the meantime, a communication was made by the Hooghly River Bridge Commissioner indicating that the said authority admitted that the due amount to the petitioner is rupees 2,61,59,800 and not the entire claim made by the petitioner. Full stop next para. A copy of the said letter is handed over in court today and be kept on record. Full stop. It transpires therefrom that undoubtedly, comma, such statement has been made on behalf of the Hooghly River Bridge Commissioners. Full stop. However, comma, learned senior counsel appearing for the Hooghly River Bridge Commissioners submits that the state is to disburse the amount which is payable to the petitioner for the HRBC to release the same. Full stop. Next para, that apart, comma, it is contended that such payment ought to be in full and final settlement of the claim between the parties. Full stop. Next para, learned counsel and learned senior counsel for the petitioner places reliance on a written communication made by his client, the petitioner, comma, a copy of which is also kept on record. Full stop. It is indicated therein that whatever amount is payable at present by the HRBC is acceptable to the petitioner, comma, without prejudice to their rights, to their other rights and contentions. Full stop. It is clarified that the petitioners given the leave to file further take out further legal action in the event the petitioners are of the opinion that further amounts are due to them in lieu of the work. Full stop. Next para. A coordinate bench order dated April 10, 2023, passed in WPA 6248 of 2023, is also handed over to court, comma, in which, under similar circumstances, comma, an order was passed by the said bench. Full stop. Next para. Upon hearing learned counsel, comma, it is clear that inasmuch as the amount mentioned in the communication of the HRBC is concerned, comma, there is no dispute regarding such amount being due to the petitioner. Full stop. Next para. However, comma, insofar as the further claim of the petitioner is concerned, comma, it is it cannot be the same cannot be adjudicated within the limited scope of the present writ petition without taking detailed evidence on the same. Full stop. Hence, comma, keeping on record the communications made by the parties, comma, WPA 13956 of 2023 is disposed of by directing the respondent number 1 to release the admitted amount of rupees 2, 61, 59, 800 dash being the principal sum to the HRBC within, I'll not give it, make it 12 weeks. I'll make it shorter, a bit shorter.
Can you make it 4 weeks?
Well, with
4 weeks will be too short.
too short probably.
Also.
Everything is being spent in the panchayat elections. Within positively within 8 weeks from date, full stop, the HRBC shall disburse the amount to the petitioners immediately upon receiving the same, comma, not later than a week from the date of receipt of the amount from the respondent number 1. Full stop. Next para. However, comma, it is made clear that nothing in this order shall preclude the petitioners from making any further claims on the same works done by the petitioner before a competent civil court. Full stop. If such a claim is made, comma, the said court shall decide the issue in accordance with law upon taking appropriate evidence as deemed fit, comma, without being influenced in any manner by any of the observations made herein. Full stop. It is further clarified that the concessions made by the parties in the present matter are without prejudice to the rights and contentions of the parties in any further litigation that may take place between them. No rest to cause urgency.
I'm getting only any claim if maintainable in law.
Very well.
In case manner, there's limitation.
Right,
to
very,
anything,
very.
that's not.
Any claim, WP disposal করলাম তারপর টাকাটা দিয়ে বললাম তারপরে প্যারাগ্রাফে গেল
কেউ ক্লেম করবে না
it is made clear যেটা প্রথমটা last paragraph আগে প্যারাগ্রাফটা it is made clear that that nothing in this order shall preclude the ওই জায়গাটা পড়ে দিন making further claims, comma, if maintainable in law. बस बाकी जा আছে
Otherwise, my lord, that if by virtue of your lordship's order, they will.
there'll be no
sometime,
outer
yes.
limit.
Yes,
They'll
my
get section 14 for this maybe, but
lord.
anyway.
Obliged, my lord.
Thank
Item 6.
6. Yes. Yes, Mr. Lai.
Yes. My lord, I appear on behalf of the petition in this matter, my lord. My lord, I mentioned this matter because it is becoming infructuous on 30th that I will be placing. My lord,
Oh.
a tender was issued by the railway authorities. My lord, all have been served. All have been served. The
So it has become infructuous.
It will become on 30th.
Oh, right.
That's why I
Yes,
mentioned
yes,
my lord.
yes,
That
right.
I first mentioned to your lordship.
Have you given this is the notice to the other side?
Notice to the other
Yes. What is the matter, Mr. Lai?
My lord. My lord, the railway authority floated a tender. I participated. I became successful. From January, I have been rendering my activities according to the tender. I'm supplying the dietary kitchen materials to the hospital of the railway hospital. Now, my lord, kindly come to page 23 for once. Page 23. That is the notice inviting tender.
Yes.
20th of December 2022. Kindly see the name of work. Supply of dietary articles to kitchen at Central Hospital, Garden Ridge for the period of 12 months.
Right.
My lord, kindly take the trouble to come to page 33 for once. This is the letter of acceptance.
No early termination clause. If you don't,
Is the termination clause is there? I'm showing
later on. Well,
Yes,
yes.
I'll
Page
be showing.
33.
Yes, sir, I'll be showing to your lordship.
Yes, yes, definitely.
Page 33, my lord. Kindly take, my lord, the reference.
Reference.
Tender number such and such for supply of such and such for the period of 12 months.
Hmm.
It is there. Page 34 as well. The second paragraph. 12 months is the time limit, which is the time is the essence of contract. So time is there, my lord. My lord, kindly see page 41. That is the agreement. Pursuant to the tender, I have entered into the agreement with the railway authority. Page 41.
Yes.
Name of the work at the top. 12 months. My lord, as it had rightly fallen from your lordship, I draw your lordship's attention to clause 8. All the rights is reserved by the administration to terminate the contract with a notice of 30 days if situation so deserves. And the second portion is also the railway administration may terminate the contract without prior notice if the contractor's performance is found not up to the satisfactory level or against railway's interest, and the decision of the railway administration in this regard will be final and shall be binding on the contractor. In case of termination of the contract by the contractor, the earnest money security deposit deposited by the contractor will be forfeited as per the GCC. My lord, I was happily doing my work. My lord, kindly come to page 43. There is no allegation, nothing, and this is not even a termination. My lord, kindly take the subject. Discontinue of supply of dietary articles.
Apart from this, no other termination.
No. And my lord, kindly see the reason. Supply of hospital diet is being outsourced through GEM tender with effective from such and such. You are therefore requested to stop supply of aforesaid items required for preparation.
What a stay of operation of this?
Yes.
Of this order.
Of this order.
Learned counsel, and despite service, none appears for the respondents. Full stop. The affidavit of service and a printout of the concerned email be kept on record. Full stop. Learned counsel for the petitioner submits that the petitioner entered into a contract with the respondent authorities for supply of dietary articles to kitchen at the Central Hospital, Garden Reach for the period of 12 months from December 20, 2022. Full stop. Next para. Pursuant to the same, the petitioner was awarded a contract on April 20, 2023 for a period of 12 months, which is also annexed as Annexure P4 at page 41 of the writ petition. Full stop. In the said contract, clause 8 stipulates that under normal circumstances, the administration has the right to terminate a contract with a notice of 30 days if situations so deserves. Full stop. It also empowers the railway administration to terminate the contract without prior notice if the contractor apostrophe's performance is found not up to the satisfactory level or against railway apostrophe's interest, and the decision of the railway administration in this regard will be final and binding on the contractor. Full stop. In such case, the earnest money / security deposit is to be forfeited as per the general conditions of contract. Full stop. Next para. However, without resorting to either of the limbs of clause 8 and without any notice to the petitioner or any intimation, even with regard to the petitioner's work not being up to the satisfactory level as contemplated in clause 8 of the contract, comma, all on a sudden on May 31, 2023, comma, much prior to the normal expiry of the contract, comma, a communication was made to the petitioner by which it was intimated in a cryptic manner that supply of hospital diet would be outsourced through G small e cap M tender with effect from July 1, 2023. Full stop. The petitioner was, comma, accordingly, comma, requested to stop supply of aforesaid items required for preparation of hospital diet immediately from June 30, 2023 onward. Full stop. Next para. Since there is nothing on record to indicate that any ground was cited by the respondent authorities regarding the petitioner's work not being of satisfactory level, or even without caring to terminate the existing and subsisting contract of the petitioner, comma, the impugned notice dated May 31, 2023 is palpably dehorates the law and also without authority and against the contract entered into between the parties. First up, since the railway authorities are public authorities and come within the contemplation of Article 12 of the Constitution of India, and the work in question is of public importance, comma, that is supply of dietary articles to hospitals, comma, the writ petition is entertained. Full stop. In view of a strong prima facie case having been made out by the petitioner for hearing of the writ petition on merits, comma, all the operation of the impugned notice dated May 31, 2023, within bracket annexure P5 at page 43 of the writ petition, bracket close, is stayed till August 31, 2023 or until further order, comma, whichever is earlier, full stop. Affidavit in opposition, if any, shall be filed by the respondents within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter, comma, the matter shall next be listed on August 7, 2023 for hearing.
In the meantime, my lord, I may be allowed to continue because they will not, your lordship.
No, the difficulty is your yes, your tenure
Yes,
continues.
tenure.
It is further clarified that until further orders, comma, the petitioner shall be entitled to continue with the work in terms of the contract entered into between the parties.
So grateful to your lordship. The difficulty is they understand in a different way. Otherwise,
Yes, you are right.
I'm grateful to your lordship.
New motion item 7.
Yes, please. What is the matter? There are private respondents also.
I am for the W visa. No.
Well, yes. Electrocution.
Yes, my lord, this is the second time, my lord, your petitioner is approaching before your lordship.
Yes.
Your lordship, I have annexed the order of your lordship at page 43. Download copy, my lord, I have obtained the certified copy also.
No, this is sufficient.
My lord, your lordship kindly see the operative part of the, my lord, your lordship's prima facie finding is petitioner is responsible, prima facie, on consideration of a workman of the consumer who made a statement before the authority behind the back of the petitioner. My lord,
You were a party there. You were a party to this previously.
My lord?
You were a party to the previous order.
Yes.
Yes.
My lord, my writ petition.
It was your writ petition.
My lord, that person, the name of that person is Sanjay Mandal, who was deputed by the consumer for repairing job, which is the duty of the petitioner. Petitioner's duty is to execute the work order, but job done by Sanjay Mandal by his man. That Sanjay Mandal was engaged by the consumer. first 2 months inquiry report has been inquiry conducted without giving opportunity to the petitioner. Thereafter, 3 members inquiry committee re-inquired into the matter without giving to the opportunity to the petitioner. Thereafter, statement taken from the Sanjay Mandal by the authority, and that statement annexed with the affidavit in opposition in an earlier petition. And that statement was read over before your lordship, and your lordship's on consideration of the very serious allegation against the petitioner. If that allegations are true, a petitioner cannot deserve to keep in the list of a listed contractor. But still he is working. Your lordship kindly see the direction of your lordship, that is operative part, at page 49. Considering all this, your lordship directed the authority. However, it is made clear that whatever action is taken by the WBSEDCL pursuant to such impugn advice and or otherwise with regard to the alleged negligence of the petitioner and its men for electrocution accident, and the same shall be undertaken upon prior notice to the petitioner and decided on an opportunity of hearing being adequately given to the petitioner in accordance with law. That is also direct. Ultimate direction is there. But prima facie view is there. My lord. Next, your lordship kindly see the notice of inquiry. Page 57. Annexure 15. I am reading your lordship.
57, yes.
My lord. Upon compliance of the order of the Honorable Court dated 5/4.
7 is some other thing, something else.
My lord, annexure
P15.
P15, my lord.
No, the pages are
My
not.
copy annexure P15.
It says 59, sorry.
59,
59, 60, next.
59.
Yes.
Xerox. My lord.
It's all right, 59.
Notice of hearing. My lord, who issued the notice of hearing? Additional CE and General Manager, who was also a member of the 3-member inquiry committee, re-inquiry committee. However, my lord, upon compliance of the order of the Honorable High Court dated such and such, in connection with the petition number such and such, a hearing shall be held at the chamber of General Manager such and such at 3 p.m. to decide the score of realization of the compensation.
Your liability was not to be decided. I mean, they did not give you an opportunity of hearing on the whether you were liable at all.
My lord, now question is the point of decision is to decide the score of realization.
Okay. They closed that chapter.
Predetermined.
Very well.
Decide the score of realization of the compensation against the fatal accident, electrical accident. Next, my lord, on the notice was sent to on 27/4/23. Next day, my lord, I made a representation. What was my representation? 28/4/23. My lord, I have received, your lordship got.
Yes, got it.
I have received a mail yesterday in which you directed me to appear on 2/5/23 in the venue at 3 p.m. for hearing in compliance with the direction as made by the Honorable High Court in petition number such and such for hearing. Your office is well aware that accident took place for doing repairing work by an outsider unauthorizedly, which fact was brought notice to the local police station by making a written complaint by your office. Your office is also aware that victim Ajay Mandal is the brother of Sanjay Mandal, who is not our employee, a man of the consumer. Your office is also aware that statement of Sanjay Mandal had been taken behind our back, and that statement was referred at the time of hearing of the case, which speaks for itself in the order of the Honorable Court. Your lordship recorded the submission of the respondent in that order. It is necessary for appearance of Sanjay Mandal at the time of giving effective hearing in compliance with the solemn direction of the Honorable Court. I am requesting you to cause his appearance on the date and time fixed by you in the place of inquiry with an intimation to me. My lord, date of inquiry was 2/5/23 and letter was given to 28/4. My lord, this is my detail. This was my primary
Let us hear them on this. What
my,
this-
my lord, thereafter I again, my lord, inquiry was.
ultimately what was done?
Huh?
Ultimately what was done?
Ultimately, a reason order was passed.
Hmm. Let us see
After,
that.
after this one letter I have sent, my lord, my regional officer, the respondent number 2,
Yes.
directed me to submit your statement in writing. My lord, I think that inquiry is still continuing. My lord, next page, 8/5/2023, I made a representation. Next page, annex.
Ultimate order passed by.
Ultimate order, my lord, held that my men or my workers are responsible for not supervising. Your lordship, kindly see the impugn order.
If it was your responsibility to supervise, you had to supervise.
No, that is not my responsibility. My responsibility is to execute the order. My responsibility is to execute the order before reaching my men at the place. Consumer engaged one man, and that man engaged one labor, and that labor climbed on the DP structure. When my employee reached there, they are sought for their
Substantial allegations against page 64. Please come to page 64.
Yes.
Last 2 paragraphs. Last 3 paragraphs actually.
Ultimate, they are that is the report. Earlier 2 reports.
They rely on
Earlier
that.
2 reports. No further evidence, no further statement, nothing. Earlier 2 reports was considered, and they are not acting properly. All that. My men were there with adequate.
When the order was passed, you are heard.
No, actually, no opportunity. My lord, kindly see, my letter was not considered in the no reflection. Only one line. I made submission, page 64. Well, submission of the proprietor of the petitioner, that is proprietor, AFCON heard vividly. Nothing is record. My lord, my specific complaint, my specific grievance, call that man who made a serious allegation against me. Your lordship, I annexed that statement annexed with the affidavit in opposition. And that statement was referred before your lordship. My man compelled that labor to climb the DP structure with an assurance to give some money. Very serious allegation, my lord. This is a reputed contractor, still is continuing his work. My lord, incident occurred in the year 2013. 2015, they have sent a letter.
I think no irregularity in the decision-making process. Writ court cannot interfere unless on the merits of the matter. If there is any difficulty in decision-making process, definitely. But is there you are heard, your submission was recorded?
My lord, where is reflection? What my submission?
Come to page 63. Read it out. Who is AFCON? You are not AFCON.
Yes, I appeared.
Page 63.
That was not my submission.
Yes.
No, that is not our submission. It is a case of the respondent.
Your representation, you say your representations were not considered.
No reflection in the order. 2 representations are there before passing this order. Just members of the committee, that I have stated. The members of the committee are happy. You have to pay. We do not know Sanjay Mondal. You have to pay. Next representation, my lord, before passing the impugn order, that is 8/5/2023. Two representations are there. My grievance are there before the hearing officer, not considered by the hearing officer, not in compliance with the direction of the honorable court. Adequate opportunities.
Let me hear them. Yes, Dr. Sharma. Please come to page 61.
I am As
You
your
will
lordship
come to the
desire-
rest.
As your lordship desire, that let me formulate that. Subsequently, I will certainly, whatever has been.
No,
followed-
only this, please come to page 61 once.
61.
Second last paragraph.
You are referred to the statement of the.
This is the second representation given by them.
Yes.
You referred the statements. This is the only substantial thing. The rest are allegations. To defame me, I am an established. I'm ignoring those. Please take your seat, sir. Please take your seat. Both of you. I appeared. The second last paragraph
I
says.
appeared in the inquiry when I found the beside the hearing officer 5 other.
No, second
persons-
last page of page 61.
Second last. Oh,
Second last paragraph of page 61. I'm sorry.
second last paragraph. I appeared in the inquiry.
After
lordship.
that.
After that. So you refer to the statement.
Sir, you refer.
Sir, you refer to the statement of the operator of WBSL and 3 workers of my establishment. Those statements not produced before the Honorable High Court, and those statements are necessary for me to ascertain the question of alleged negligence on the part of our employee. Kindly supply copy of the statement to me.
So how could you rely on the report without giving him a copy?
They are trying to reopen the issues, whatever attains finality. Lordship, my humble submission before your lordship. If your lordship kindly see their first allegation that no opportunity has been given to them.
First allegation I'm ignoring.
And-
Opportunity has been given. Let us
But
forget.
not
those.
only that.
I'm only asking you
this
this.
is the second round of
Why
litigation.
didn't you give them a copy of that report?
But entire thing has been given to them. They are saying that has not been given. Kindly see. And their workers is their workers. It is not that
I'm not deciding the merits.
Yes, lordship, kindly see.
If you rely on a report, you have to give a copy to the
My
person.
entire thing has been given to them prior to that. Lordship, kindly appreciate.
When
In
did
the
you give them the entire thing?
first round of litigations, in the affidavit, in oppositions, entire statement has been recorded. That was before him. They are trying to distort the fact.
You annexed that report on which you relied
Yes, in the affidavit in opposition.
in the opposition of the previous litigation.
Yes, and that has the finding of this court also. I will
Show me that finding, my finding.
And they are saying that no opportunity has been given. If your lordship kindly come to page 34. Page 34 onwards. That is on the 2/3/2015. Reply to the show cause. They have been show caused after the accident. Again, your lordship will find that sufficient opportunity. Next, this is for your information. In the next page. Lordship got that? Next page.
Yes.
35. That Oja late working under your control was made and fatal accident. What happened, your lordship? The thing is, the gamut of the situation that the West Bengal state, this is for the bulk consumer. They have made a representations for shutting down their premises electricity. And it was generally given to the contractors. And they take huge amount from the WBSL as an agent. Now, on that pretext, they have been assigned to that work and they have been given responsibility that there should not be any fatal accident and they should take care of that. And for that, entire PPT, dress, everything has been given to them. Now, what happened, your lordship, kindly see, that series of representation they have given, the same prayer has been given by them regarding the Ajoy Mondal and that, and your lordship will find, next, lordship, kindly come to page 37. This is prior to the
No,
first
they
litigation.
took this point previously also.
Yes.
Page 39, August 28th, 2018, as far back as then that date. Page 40, they take this. Page 18, page 28, I'm sorry. Page 38, it starts. Not 38, 39. Page 39, it starts and come to page 40.
Yes. In the
Page 40, second last paragraph, they've categorically stated without affording the firm an opportunity of hearing and or furnishing the copy of the report of inquiry on the basis of which such liability has been cast.
Lordship.
So after that, show me something.
After that, there was a specific order in my affidavit. We have already given the entire reports, entire statement, and thereafter kindly come to the order, page 43.
Yes, 43.
Onwards. May I place the order? It will be crystal.
Place the relevant portion where I have
Yes,
referred to
yes,
that
sir.
report.
Relevant portion is
Report. I want to see a reflection that the report was handed over.
Learned Counsel. Now, report, there was in the affidavit in opposition, the report has been submitted on the basis of the statement given by the each of the person, your lordship has come to the finding. In my affidavit in opposition, entire thing has been given, lordship. Kindly see, learned counsel places reliance. This is the on clause 7 of the additional observation of the accidental inquiry committee appointed by WBCL, which is annexed at page 27 in the affidavit in opposition filed by WBCL to harp on the point.
These observations of the accident
Yes,
inquiry
yes, yes.
committee that was the report.
That was the accidental committee has said after going through all the documents that the compensation of 4,23,000 is to be given. That is at page, lordship will find at 38.
What report are they speaking about?
But that report after going through the inquiry, after considering the accidental, your lordship knows that under section 161 of the Electricity Act, if any accident took place, then inquiry is to be conducted. Thereafter, the inquiry has been conducted, a committee has been formed, and after giving opportunity to them, thereafter, the findings has been made on 24/8/2018. This compensation is to be allotted. And they have taken out this writ petition by challenging this accidental report. And on that pretext, with these representations, if your lordship kindly come to this order itself. May I place from page 44? It is contended that WBCL, without any opportunity of hearing given to the petitioner and going contrary to his own inquiry report, has sought to take a penal action against the petitioner and has withheld the amount of compensation paid to the family of the compensation has already given to the victim family by deducting the same from the dues of the petitioner. That apart, it is argued that entire gamut of the allegation made even in the police case initiated is against the Sanjay Mondal. Same thing, your lordship, and not against any employee of the present petitioner. As such, it is contended that WBSC be directed to disburse all dues of the petitioner, including the amount withheld in lieu of compensation. Learned counsel appearing for the WBSL places reliance on the statement of Sri Sanjay Mondal, as whose BS allegedly the victim has undertaken work in question which led to unfortunate electrocution. That statement in the affidavit in opposition, there was a statement of the Sanjay Mondal, Lal Babu, their employees, everything has been annexed there. It was contended, it is stated that Sanjay Mondal, that Lal Bahadur himself disowned the responsibility of making such disconnection and directed the Sanjay Mondal and his men to effect disconnection themselves. As a consequence, after being assured by the Lal Babu that electricity supply has been disconnected to the line, the work was undertaken by...
Yes, page 46, third paragraph, it is referred to also.
I'm going to
Let us come to that. It is further submitted that
in accident report itself, which is relied upon by petitioner, clause 9 is...
The petitioner relied on the accident inquiry report.
Clause
they said it was contrary, your decision was contrary to that.
And clause 9 is clearly consonance with the statement of Sanjay. It was stated, clause that since Lal Babu and his men refused...
Yes, Dr. Shara, I'll pass my order. I'll not interfere. Sorry.
Lordship, they are saying
because I opened my mouth.
all statements has been supplied to me. No, that is not correct. In opposition, only statement of Sanjay Mondal has been annexed. Only statement of Sanjay Mondal, that is serious allegation against the petitioner. That's why I asked the hearing officer to call him. Why?
There is a point after which you'd have to stop, sir. Please. Learned counsel for the petitioner argues that the petitioner was not served with a copy of the inquiry report and the other relevant reports, on the basis of which the respondent authorities fixed responsibility on the petitioner regarding payment of compensation, which was ascertained to the tune of rupees 4,50,440. First up, it is argued that no opportunity of hearing was given to the petitioner insofar as the petitioner was not served with all relevant copies of documents. First up, next para, that apart, in the impugned decision dated May 18, 2023, which is annexed to the present writ petition, the submissions of the petitioner and/or the contents of the petitioner's representations were not reflected at all. Full stop. Hence, it is submitted that despite the petitioner concerned having no role to play in the concerned accident, for which electrocution took place and damages were given, comma, the entire order impugned herein ought to be set aside. For sub next para, learned counsel appearing for the WBACDCL places reliance on the order of this court dated April 5, 2023, which is also annexed to the writ petition, and submits that such question of liability was conclusively determined therein. First up, it is further contended that all the documents which are relevant in the context, comma, were handed over to the petitioner or, comma, at least, comma, annexed to the affidavit in opposition of the WBACDCL in the previous writ petition, and were considered by the court. Full stop. Only upon such consideration, comma, the order was passed directing the WBACDCL to give a notice to the petitioner and decide the compensation upon giving an opportunity of hearing to the petitioner. Full stop. Next para. In the context of the allegations made by the writ petitioner, comma, the order dated April 5, 2023, passed in WPA 17816 of 2018 in the previous round of litigation between the parties is required to be looked into. Full stop. Certain salient features of the same are required to be mentioned here. Full stop. First, comma, it is seen that learned counsel for the petitioner, comma, as recorded in the said order of this court, comma, had then submitted that in the accident inquiry report, capse, inquiry report of the WBACDCL itself, comma, which was relied on by the petitioner, comma, clause 9 was clearly in consonance with the statement of one Sanjoy Mondol. Full stop. Next para. That apart, comma, there are further references by the petitioner to such report. Full stop. In fact, comma, it is found in internal page 2 of the said order dated April 5, 2023, that learned counsel for the petitioner had also placed reliance on clause 7 of the additional observations of the accident inquiry committee appointed by the WBSEDCL, which was recorded in the order to have been annexed at page 27 of the affidavit in opposition filed by the WBACDCL to harp on certain points. Full stop. Upon giving extensive hearing to the petitioner as well as the WBACDCL on the said occasion, comma, the writ court had come to the finding that upon a perusal of the materials annexed to the pleadings of the parties in the said writ petition, comma, it was clear that even in the inquiry report filed at the behest of the WBACDCL, comma, the clear aspersion for being responsible for the accident was on the employees of the petitioner, comma, namely Lal Babu and his people. Full stop. Next para. Upon certain other findings being rendered, comma, the report was discussed at length, and it was also observed that the allegations in the report say that Lal Babu and his men, comma, the employees of the petitioner, not only instigated the victim to undertake the work in question, but also assured him that the conductor had been isolated, comma, upon which the victim met his demise. Full stop. Next para. Clause 4 of the communication dated August 24, 2018 was also considered by the court. Full stop. Ultimately, comma, it was observed that to subserve the principles of natural justice, comma, before taking any stringent action to double inverted, comma, including deduction of the amount of compensation from the petitioner's dues by the WBACDCL, comma, such principles were required to be adhered to. Full stop. Next para, in such context, comma, the writ petition bearing WPA number 17816 of 2018 was disposed of without interfering with the communication dated August 24, 2018, impugned therein, comma, seeking initiation of action against the petitioner on the score of realization of the compensation amount. Full stop. Hence, comma, on the basis of the concerned reports, comma, which are germane for the present consideration, comma, the court had clearly observed that it was not interfering with the impugned communication, whereby initiation of action against the petitioner on the score of realization of compensation amount was sought. Full stop. The only rider thereto was that prior notice and opportunity of hearing was to be adequately given to the petitioner. Full stop. Next para. It is seen from the materials annexed to the present writ petition that not only was a notice of hearing duly served on the petitioner, comma, the petitioner had the further opportunity of filing written representations, comma, at least two of which are already on record. Full stop. In the representation of the petitioner dated April 28, 2023, annexed at page 60 of the writ petition, comma, it is seen that the petitioner took a point that the accident took place for doing repairing work by an outsider unauthorizedly, and that the victim Ajay Mondal was the brother of Sanjay Mondal, who was not the employee of the petitioner, but a man of the consumer. Full stop. It was also indicated that a statement of Sanjay Mondal had been taken behind the back of the petitioner, and the statement was referred at the time of hearing of the case. Full stop. Next para. Sanjay Mondal was also requested to be made present at the time of hearing. Full stop. That apart, comma, the statements made in the inquiry report were controverted. Full stop. Next para. In the reasoned order dated May 18, 2023, comma, the respondent authorities clearly recorded that the representative of the petitioner was also present. Full stop. Next para. Upon giving adequate hearing, comma, it was observed that after going through the reports of the inquiry committee and subsequent submissions made in the hearing, comma, it was revealed that a fatal electrical accident took place on January 26, 2013 at about 10:30 a.m., where Ajay Mondal, aged about 19 years, was a victim. Full stop. Next para. Thereafter, comma, the submissions of the petitioner were recorded to have been heard vividly, and thereafter the cause of the accident was considered. Full stop. The concerned committee had taken into note the relevant factors. Full stop. The respondent authorities also took into consideration the report of the committee, comma, which was a part of the pleadings in the previous writ petition and were addressed duly and comprehensively by the petitioner therein. Full stop. Hence, comma, at this stage, comma, it cannot be said that the respondent authorities relied on some extraneous documents which the petitioner did not have the opportunity to go through. Full stop. In any event, comma, a perusal of the impugned order does not reveal anything to show that there was any illegality or patent irregularity in the decision-making process, comma, which is the limited window of interference by a writ court. Full stop. In the absence of any palpable illegality, comma, I do not find any occasion to interfere with the impugned decision. Full stop. Accordingly, WPA 13332 of 2023 is dismissed on contest without any orders to cost. Full stop. Urgent certified copies.
Lordship, only in opposition, only one statement has been annexed. Other employee statements were not annexed.
There has to be a finality somewhere.
One.
Thank you.
Item 8.
8.
But this is my application.
Service, what about
Yes,
service?
yes, all.
I'm
All.
for the respondent bank.
Yes, what is the matter?
In spite of obtaining succession certificate, but that bank did not disburse the dues amount. Against that, this writ application has been filed.
Why not?
If your lordship,
I'm paying apology, Your Lordship, unconditional apology for the delay. But Your Lordship, please,
Disburse.
no, not disburse. Please kindly ask the petitioner to cooperate with the bank. If any
What cooperation? Tell me. How
another
much money has to be paid?
2 lakhs something.
2,10,000.
By you to him or him?
No, I am bank. I have to disburse as per the succession certificate.
What cooperation do you want?
Any further documents, including indemnity bond.
Tell me
Why
what the-
indemnity
what-
bond? There's no record.
Tell us what documents are required. Disclose that. I'll tell him right now. I'll record it in my order. He'll produce those and then give.
Kindly process as per the banking.
No, I'll not keep it vague. You'll have to disburse the amount now.
Oh, yeah, Lordship, there is no embargo on the bank. Please,
So I'll direct you to disburse within a week.
within 2 weeks,
Bang.
only as per after obtaining any further documents with including indemnity bond. if
What
it's
document?
necessary.
Tell me, then I'll direct. Indemnity bond for what?
Succession
Their
certificate.
identity proof they have to give. That they'll have to give.
Yes.
Succession certificate they'll
Yes, but
produce.
as per banking norms, Lordship, their
What are
bank,
the norms? Tell me. They are laymen. I am also a layman in banking. So you have to tell me what documents they have to produce. Tell me they'll produce.
then Lordship kindly direct to bank will
Make a phone call.
probably-
I'll pass it over for 15 minutes. Come back and tell me what
Lordship,
documents are to be
Lordship,
produced.
Lordship.
Whenever you are finished, just inform your learned friend. Please be there. Come back.
Yes.
After the continuing matter is over, just tell me. I'll take up the matter and pass my orders.
Lordship.
এটা সাইড করে রেখে দাও। এটা যখনই আসবেন উনি তখনই পড়তে।
Item 9.
9. None appears for the parties. You're for the?
In item number 9.
It's obviously
I'm
9.
for the petitioner.
What is that?
Mr. Arindo Mondal was here in a matter in court number 1. He had transferred. Can you make it?
This is for the respondent.
For the state respondent.
His presence is necessary.
Not necessary, my lord.
Not necessary. What is the grievance?
Order may be passed. Kindly see.
Then I'll make it not to.
Kindly see page number 19. I'll make it short possible.
No short possible. Page 19 years. What is your grievance?
Can you see in 1990 the
Hot stamp paper?
Yes.
That is the allegation. They are holding over your document. You want to pay the
Yes.
amount of this-
That is the priority also.
the in this where is your affidavit of service? File it.
Affidavit of service.
That is with the other side.
No. Oh, well, he has come. Yes, he has come.
Still, you have to file the affidavit of service. Otherwise, there may be collusion between you. So, usual order I'm passing, Mr. Mondal, that they'll put in the entire amount and you'll release the amount.
Also, only two things, because only two things. Also, kindly comes to
In the Mondal
page, because I'm not going to stand in the way. The only two things.
If you're not standing in the way, let me pass my
No,
order.
two things only. Just for my own sake.
For mental satisfaction.
Yes. Now this is a club. Now, so sees the
Whatever, what club?
No, amendment made in paragraph 1 and 2. There's no reference of that. Number 1. Yes. Number 2. Please also have a look at page 19 of the writ petition. It mentions that the value of the property is 1 lakh. So if it is only, they are saying only 1,000 rupees, 70 rupees. So whatever is the deficit that they have to also file, because 1% cannot be the stamp duty of a value of a property value.
So, it's your liability to say, tell them what is the deficit duty.
Your Lordship, if they make a representation, we can.
They need
consider-
not. Why should they?
Yes, yeah, I
The
understand
moment
this-
it is presented for registration, you have
that
to
was wrong
inform
back,
them.
1980s, I think, or something like that. It's
Have you
wrong back.
intimated anything to them?
Oh.
Something else is required.
We can't do that because 1% cannot be, it is admitted position.
Who admits?
No, he says that 1 lakh rupees, for 1 lakh, he has deposited only 1,000 rupees. That is admitted. He doesn't say anything more. It cannot
Show me
be.
from the Stamp Act, it's more.
Stamp Act, it was 6% at that point. I can put it in my
So
opposition.
then you have to intimate them.
We can do that. The requisite amount, we are not going to.
I'll keep it there on Monday. Please intimate it.
Yes, on one.
In writing, take written instructions to
In
protect your own
writing,
skin.
in writing, then kindly gives me some more time. Only a few, because there is.
I don't know how to write.
Yes, it will be given to the petitioner. Just give me some more
You
time.
will get it. Written instructions, you will file it in court. I'll keep it on record and direct them to pay that amount.
Very well.
Learned counsel for the petitioner submits that on the ground that the stamp papers in question were forged, comma, the sale deed of the petitioner presented for registration long back, comma, has been withheld. Full stop. Next para, it is submitted by learned counsel for the respondent authorities that the stamp paid was minimal and not the requisite stamps. Full stop. Hence, comma, it is submitted that there is deficit stamp duty. Full stop. It is, comma, however, comma, unfortunate that nothing has been intimated from the end of the respondent authorities to the petitioner till date, comma, regarding deficit stamp duty stroke registration fees. Full stop. However, comma, since such a stand is taken by the respondents, comma, learned counsel for the respondents shall file a written instruction on the next returnable date indicating as to what is the exact deficit stamp duty payable by the petitioner in order to dispose of the matter finally. Full stop. The matter shall next be listed on July 5, 2023, next Wednesday.
I'm deployed.
Thank you. Fairly at the top of the list, kodo, chotto order hobe. Next. Dr.
Item 10.
10. Yes.
10, your lordship, appear for the petition.
Yes.
I'm for the state, my lord.
Lordship.
You're for the
State, my lords.
State Bank.
State.
State. All right. Yeah.
Lordship, all the respondents have been served.
Right.
I permitted
right.
to file the affidavit of
What is the dispute?
Lordship, this is the dispute again, your lordship, with regard to rate revision, your lordship, on the last occasion, your
With
lordship.
regard to, I'm sorry, I couldn't get it.
Lordship.
With regard to?
Lordship, the petitioner is running a biomedical facility, your lordship.
Oh, acha, that.
Lordship, that was for another zone, your lordship. Herein, there is some difference, your lordship.
Yes.
This is a plant to product. This is a plant which is run at Mograhat, South 24 Parganas.
Have you got a copy of previous?
That order, your lordship.
What is the difference? Tell me there.
No, lordship. The only difference is that, your lordship, there was a 2016 tender, 2016 memorandum. There was an agreement. The clause 26 remains same. There is only one representation which I shall place, your lordship. That is at page 108.
Well, I'll take that break and come back and
Lordship.
with 10 minutes.
Lordship,
Item number 8, ও চলছে?
I'm in a continuing matter, yes.
Lordship, I'll be placing reliance on the biomedical rules of 2016, Your Lordship, page 45. This is a continuation of the rules.
Right.
Lordship, page 45, 7, clause 7, subclause 4.
Yes.
Lordship, it states, in case where services of the common biomedical waste management facility is not available, the occupiers shall set up requisite biomedical waste treatment equipments like incinerator, autoclave, such and such, as per the authorization given by the prescribed authority. Lordship, the reason for placing only this particular clause is that the occupier are the medical institutions, and the operator are these persons who are providing this disposal facility. So in the event, in a particular area, if the facility, if the biomedical treatment facility is not available, then it is open to the occupier, that means the hospitals, to set up their own incinerator and processing and everything with authorization. This authorization is only can be given by the PCB and the constituted advisory board, as is recommended only by this rules. Lordship, there is no such options other than using the facility of the petitioners and others. This is the only reason of placing this clause. Lordship, thereafter I have entered into an Lordship, thereafter
How is this German for your dispute? I mean, you are wanting the fresh rates to be given to you.
Fresh rates, Your Lordship, this is only German because they are continuing with our service. There is no disruption of service, and they could have stated that we are not inclined to take your service or we have not extended. But if they do not want to admit that, Your Lordship, this is the only purpose this clause is important, Your Lordship. Page 66, Your Lordship, is the 2016 memorandum.
Right.
The zones, on the last occasion it was zone 1, Your Lordship. Page 67 is zone 6, Mograhat.
Right.
Lordship, this is where my plant is, and it is operating for the places South 24 Parganas, and those are the hospitals which are covered.
The
Page
clause is the
67.
clause 6 also, here also. 26 and
Clause 26 is at page 76.
Right.
The same clause.
Same clause.
19 February 2016 agreement, the same clause. With a 4% increment, and at that relevant point of time, the rate was 4.87, which was subsequently made to only 5 point something, where I'll be praying for an enhancement at the rate of ₹8 per bed per day. Lordship may kindly takes page 129. Page page 129.
Yes.
Lordship, I'll be praying for implementation of this rate chart, which
Do you agree to the rate chart?
Lordship, the rate chart is at P11, and that is my calculation.
No, the rate chart is at page 131.
131, Lordship. That's P11. The rate chart is at page 106.
Achha.
Lordship, the last is 13, South 24 Parganas. It is ₹8. At the very top, it is written accepted rate in INR per bed per day.
Right.
I'll be praying for an enhancement at the rate of ₹8. Lordship, thereafter kindly takes up page.
What is the present rate you're getting?
Present rate, I am working at 5.69.
Very good.
And the arrears along with the rates is what is at page 129, which is annexure 3 to my representation dated 6 June 2023. Page 129, Your Lordship. Lordship kindly takes up page 129. This is the calculation.
You're wanting the rate, the effect to be given from which date?
From December 2019. Lordship, P11, page 106 is also from 2019. P11 is dated 16th May 2019. and I am praying for an enhancement from December 2019.
Yes, what do you say?
My lord, so far as the enhancement of rate, we will ready to increase, my lord.
Very good.
But in case of my lord area, what she wants, my lord area, then
No, it has to be from December 2019, isn't it?
No, my lord, it will take some time, my lord, to talk with my lord, the finance department, my lord. So for the enhancement of rate, will be ready to increase from today.
No, enhancement has to be given definitely.
Yes, my lord.
But that is on a different aspect. I'm not recording your concession on that. So I'll make it an order of the court. But since the enhancement was December 2019, why not from that date? Because in the previous order, it was recorded that such effect from the date of publication of the finalized tender rates shall be given as expeditiously.
Then my lord, kindly increase the rate.
I'll put it in the same language then.
Lordship, there is only a consideration of Lordship to that
The
the state
exact
was.
quantum I shall not quantify.
Lordship, since submission is made on behalf of the state that they are accepting that we are entitled to the
That is
rates of.
qualified submission. They are also saying they will not give from that date. So
Lordship,
if I
but
have to
they,
record, I'll have to record the entire thing.
Lordship, I'm only praying your Lordship on the last occasion. State was not represented. Otherwise, they could have given their consent that we are accepting the rate of ₹8. Lordship, and the areas your Lordship may kindly directs them to decide on the basis of the clause 26
Very
with
good.
regard to the areas.
Give the effect immediately, and the areas regarding that, they'll be, you will calculate, and
Instruction will
I'll give a
from-
limited time within that to that.
Grateful to your Lordship.
Thank you. Learned counsel for the petitioner contends that despite enhancement of rates for supply, you are supplying cooked diet.
Lordship,
Oh, this is different.
Lordship, this is, I am collecting biomedical waste and I am
Sorry, yes,
disposing.
right. Despite enhancement of rates regarding the work of collection of biomedical waste from government hospitals for certain areas, comma,
South 24
the same is not being given to the petitioner. Pushed up next para, it is contended that in terms of clause 26 of the agreement, comma, where is clause 26? What is the page
Page
number?
76.
Comma, the rate agreed to between the parties was subject to change after fresh tender rates are finalized. Full stop. Next para. In the present case, comma, it is argued that the petitioner's contract is being continued with by the respondent authorities, comma, however, comma, the fresh tender rates have not been applied to the petitioner. Full stop. It is argued that the petitioner, comma, which is working for zone 6,
Page 66, 67.
zone 6, as per the notification, relevant notification
Dated 22/1/2016.
dated January 22, 2016, comma, annexed at page 66 of the writ petition, comma, and that the effect of the enhanced rates ought to be given from the month of December 2019, comma, when the enhanced rates came into force. Full stop. Learned counsel also places reliance on annexure P11 at page 106, which indicates a chart regarding the accepted enhanced rates per bed per day. Full stop. Next para. Learned counsel appearing for the state contends that the state, comma, on principle, comma, has no difficulty in applying the enhanced rates to the present petitioner in terms of clause 26 of the contract. Full stop. However, comma, it is submitted that the arrear rates ought not to be directed to be paid. Full stop, next para. However, comma, upon considering clause 26 of the agreement between the parties, comma, it is clear that there cannot be any reason why the enhanced rates will not be applied to the petitioner as per the agreement between the parties, comma, from the date of such enhancement being given effect to. Full stops, the said enhancements having coming into force from the month of December 2019, comma, the payments are required to be made to the petitioner at the enhanced rates from the said month. Full stop. Accordingly, WPA 14423 of 2023 is disposed of by directing the respondent authorities to disburse the amounts payable to the petitioner in terms of the work done by the petitioner as per the contract between the parties, comma, at the enhanced rates from the month of June 2023, July 2023, full stop, insofar as the current, insofar as the arrear rates are concerned, comma, the same shall also be paid at the enhanced rate as depicted in the chart annexed at page 106 of the writ petition from the month of December 2019 till June 2023. Full stop. Such arrear payments shall be made by the respondent authorities as expeditiously as possible, comma, positively within 2 months. Within 2 months from date. Full stop. Anything else? Nothing else?
Lordship, Lordship.
No address to concern.
Grateful to your Lordship.
8 ever taken.
Lordship, may I pray for one indulgence, your
Yes.
Lordship? Lordship, this is a Jalpaiguri bench matter, your Lordship. I've been trying to file it, your Lordship. What happened, your Lordship? Yesterday and the day before yesterday, the entire day, the Port Blair and the Jalpaiguri, the server was down, so no filing could take place, your Lordship. Today also, they are not allowing the filing because only we have a date on Friday, your Lordship. And the department says we have to
So
obtain
that
a
you'll have to
leave,
talk with the Chief Justice.
Lordship, leave from this court, your Lordship. Lordship, without that, the filing will not be
No, no, no,
permitted.
no. I cannot give that leave because it's technically not feasible. There
Lordship,
is some difficulty in coordination between the two.
Lordship, there
Your application will be nowhere then. Neither here nor there, literally.
Lordship, it will be filed today with the with your Lordship's leave with the date of 28th, your Lordship, with the date of Friday, your Lordship. That can be made, your
How
Lordship.
can it be? Where will it be filed? Here.
Lordship, here, the Lordship, this is the principal bench. We can file it. Lordship, the entire day the server was down for Port Blair and Jalpaiguri yesterday. No file, not a single filing took place.
No, Jalpaiguri bench is not in circuit now.
No.
Oh, it's. So now I cannot give the leave. How can I give the leave now at 12:22? You should have mentioned in the morning then.
Lordship, in the morning we were trying to get it filed at the department, your Lordship. Then they have communicating you have to obtain a leave from the Honorable Court, your Lordship.
Very leave granted, yes.
Lordship, grateful.
Leave
to
to
your
the 8 টা ডাকো।
Lordship. Grateful to your Lordship.
Item 8.
জলপাইগুড়ি ম্যাটার বা পোর্ট ব্লেয়ার ম্যাটার যদি ফাইল না করতে পারার জন্য কিছু বলে সেগুলো লিভ দেবো তাহলে এখন। Yes, 8. Yes.
Yes, Lordship, now the matter has been cleared. The bank manager is present. Actually, Lordship,
He is
the
not required to come. Yes.
branch who is was Baliganj branch where they have made application.
Right.
Thereafter, the said branch has been merged with South Kolkata branch in December 2022.
Yes.
And that's why they are not able to find the documents they have submitted.
What documents do you
The
require? Tell me.
application form as per bank norms with KYC, copy of succession certificate.
I will give. Should they apply afresh? That will be easier for you.
Fresh application.
Very well done.
Application form, Lordship, application form itself include one affidavit, one indemnity. It includes with the application form.
Along with the connected documents, the relevant
Yes, yes,
documents.
yes. Only fresh application.
File it by day after tomorrow.
I finally
No, South
indemnity
Kolkata
more
branch,
not
branch
required. Indemnity what?
No, it's including with their application form. Bank have
Application
one
form,
application
KYC and
Form and whatever is required by the application form,
Yes.
deposit those.
with KYC, so copy of succession certificate.
KYC, why not?
No, QIC, yes.
Yes.
I'm indemnity bond,
Why
what
they
requirement of the
shouldn't have
indemnity
any
bond?
objection to it.
This
No,
is
no,
the
indemnity
successions.
bond is required. Indemnity
Yes, as
bond.
per with the application form, it has been already attached. Application form, and one affidavit, one indemnity bond. In all matters of Indian bank, it is necessary.
Then you do it. Why not? Learned counsel for the petitioner submits what is not being disbursed, you said?
As per succession certificate, 2 lakhs.
10,000.
10,000.
No, no, not the amount. I mean, this is
Well, if your lordship kindly come page 22, no, 21, sorry. Serial number 4 and 5, 1,60,000 and 50,000.
you are the husband.
No, I am the father-in-law.
You are the brother-in-law.
Yes.
Learned counsel for the petitioner submits that despite being, you are the nominee.
No, my lord, I'm not a nominee, but I'm a legal heirs of late
No, if there is any other nominee, then they are entitled to take.
No, there is no nominee.
This is account on the demise of the account holder.
Yes.
If there is a nominee, then the nominee has to get.
No, there is no nominee.
Do you have any instruction on that?
No, your lordship.
I'll direct them to process it immediately.
As per banking norms,
Learned counsel for the petitioner submits that upon the demise of Kolpita Bose, comma, the petitioner, comma, as brother-in-law and legal heir of the said deceased, comma, is entitled to the amount lying in the account of the said deceased. Full stop. Accordingly, the petitioner had applied for disbursal of the amount, but has not yet been so paid by the bank. Full stop. Next para, learned counsel appearing for the respondent bank submits on instruction that in view of merger of two branches of the bank, comma, the concerned documents filed by the petitioner, comma, if any, comma, cannot be located. Full stop. Accordingly, if the petitioner files a fresh application along with relevant documents required, comma, the bank will immediately process the same and disburse the amounts according to banking norms. Full stop. Next para. Hence, comma, WPA 13928 of 2023 is disposed of by directing the petitioner to apply in a fresh application form for disbursal of the amount standing in the name of the deceased Kolpita Bose in respect of the concerned accounts to the respondent bank, comma, along with all necessary documents required to be filed therewith. Full stop. Upon such application and connected documents being filed by the petitioner, comma, the banks shall process the same immediately and, comma, and disburse the account payable to the petitioner, comma, in terms of banking norms, comma, as immediately thereafter, comma, positively within a fortnight from the date of application. Within a fortnight from the date of such application being made. Full stop. No address to cause urgent certified copies. Parties shall act on the server copy of this order without insisting upon prior production of a certified copy.
lordship,
Thank you.
presence of bank manager will be required.
I did not direct him to personally be present. He is good looking, but I did not require to see him. Thank you. But
11.
11, yes.
I'm for the petition.
Yes.
This is my affidavit of service.
Good service effect, you are appearing. Yes.
I am a formal party here.
But the state.
For Union of India.
Oh, yes.
My lord, respondent number 3, without the petitioner took loan of rupees 15,24,000 against a used truck. Thereafter, he paid 16,38,000. But the muscleman has been engaged by the respondent number 3 to
bank.
You are not the bank, financial institute. You are for the Union of India.
I am a formal party. I have nothing to do. They said, my lord,
because
as per the RBI guidelines, my lord, the agreement has to be handed over to the borrower.
At the time of
signing up the agreement, they have not followed it. The bank has not followed it. That is the reason because
financial
RBI is
institution.
involved, so they have made us a party.
What is the relief claimed here?
Well,
Release of the truck.
No, they have not yet
What do you want here? Why the writ petition?
My lord, let my representation be decided by the respondent number 3, my lord. I have already made an application before them to adjust the amount, my lord.
Where is your representation?
My lord, kindly come to page 19, my lord.
You want actually a copy of that loan agreement?
No, my lord. I have took financial assistant 15 lakh something.
What have you written in that representation? You have annexed the guidelines also. That's why I'm asking you. Just tell me. Your representation is at page, what was the
19.
page?
It starts
Page
from
19, I'm sorry. Yes. Yes, your entire objection is on that.
Yes, my lord. My lord, let them consider and adjust the amount, my lord, with the principal amount, my lord.
I'll direct them to furnish a copy of the loan agreement
That is
itself.
their principal prayer.
Yes.
What I find.
Why consider a representation? Considering will
Already
take
paid, my lord. All entire loan amount already paid, my lord.
That he will satisfy them, my lord.
My lord, 15 lakh 24,000.
counsel for the petitioner contends that despite the petitioner having given a representation in the form of an objection within double inverted objection on May 29, 2023, the respondent number 3 bank has not yet considered the same. Full stop, it is submitted that the musclemen of the bank have seized the vehicle of the petitioner.
Tried to seize. Tried.
Oh, have attempted to seize the vehicle, musclemen attempted to seize the vehicle of the petitioner on the allegation that the petitioner has not repaid the loan, although the petitioner has been paying installments. Full stop, next para. However, it is seen from the prayers made in the writ petition as well as the said representation, annexed at page 19, that the primary concern of the petitioner is that no copy of the loan agreement between the parties has been handed over to the petitioner. Full stop. Next para. Hence, WPA 14453 of 2023 is disposed of by directing respondent number 3 bank. Respondent number 3 bank যেখানে লিখেছে ফিনান্সিয়াল ইনস্টিটিউট হবে জানো, একটা ব্যাংক না, সব ব্যাংকগুলো কন্ট্রোল ফাইন্ড করে ফিনান্সিয়াল ইনস্টিটিউট। Directing the respondent number 3 to serve a copy, to hand over a copy of the loan agreement between the petitioner and the respondent number 3 to the petitioner at the earliest, positively within 3 days, 3 working days from communication of this order to the respondent number 3. Full stop. Next para. Upon getting such copy of the loan agreement, the petitioner will be at liberty to take further steps in accordance with law if the petitioner has any other grievance against the bank on such score. Full stop. Nothing in this order shall prejudice such further right of the petitioner. Full stop. The parties shall act on a server copy of this order. Full stop. Next para. It is made clear that further service has not been directed on the respondent numbers 2 and 3, in view of the innocuous nature of the order passed. Full stop. The respondent number 1, Union of India, in any event, is only a proper party, but is represented in court today through counsel. Full stop. এটা তো আগেই dispose of বলে দিয়েছি, no address to cause.
My lord, let them restrain, my lord. Kindly restrain their muscleman, my lord. My lord. But I already paid, my lord.
Why?
Already they are trying to.
Writ court cannot do that.
Let them restrain to repossess my vehicle, my lord. By using the muscleman, they are without
Not
following
paid the loan, they will repossess. If you have a remedy, you have before the tribunal, debt recovery tribunal, you go there.
Without having the copy of the loan agreement, I am totally in dark about the terms and
copy.
conditions of the loan agreement.
That's how it will be on the server today, communicate it tomorrow, get the order by Monday, get the loan agreement by Monday.
If they won't furnish, man, I'll.
Deeply
12, yes. What is your matter? Yes.
Lordship, in this matter,
Apart from
notice,
time, argue whatever you can. No time.
Lordship,
Move the
notice
matter.
is yet to be served upon all the respondents.
On the prayer of learned counsel for the petitioner, let the matter stand adjourned for the week.
Thank you, Lordship.
Next.
For the principal.
Yes.
I'm for the state.
Right. State is the main respondent.
My lord, state.
What is the allegation?
No allegation.
No allegation, man.
I'll see the synopsis first. No allegation.
Only
Peculiar type of case, my lord, that petition. Item number two, উপরে লিখবে।
Legal. Why legal clearance? I mean, under which
Page 11, my lord.
Yes. ma'am. Age, my lord, age is the bar, I think. What reveals, my lord.
Unfortunate, yes. So legal aid clearance has to be given by which authority?
My lord,
Health. This one number two.
this one too.
This one number two, my lord.
Under which provision is this required? As per government regulation, no regulation you have cited.
No regulation I could not find, my lord. The night also I could not find.
Very well. The prayer made in the writ petition is innocuous. Full stop. Learned counsel for the petitioner contends that one of the children of the petitioner expired due to a fatal disease at the age of 11 years, and the other is married and currently does not live with them. Full stop. Hence, comma, they are looking for another baby and seek to undertake an IVF treatment. Full stop. For the same, comma, legal clearance is required due to the age of the petitioner. Full stop. Next para. Upon hearing learned counsel for the parties, comma, WPA 14490 of 2023 is allowed, comma, thereby directing respondent number 2 to, have you applied before them?
No.
Respondent number 2 to treat the present writ petition as an application by the
yes.
petitioner on such score and process the same immediately. Full stop. Thereafter, comma, if there is no other impediment in law, comma, the respondent number 2 shall grant the
Clearance.
Clearance.
Grant the clearance, grant the legal clearance as per the prayer of the petitioner. Full stop. Such exercise, comma, it is expected, comma, shall be concluded by the respondent number 2 within a fortnight. Within a fortnight from date.
Fortnight, no,
3 weeks.
3 weeks. ma'am.
Within 3 weeks from date. Thank you. This has nothing to do with Panchayat.
No. Grateful, man.
Grateful.
Thank you. Next.
14,
Here for the other side, the respondent.
Still, my
Yes, who is for the petitioner? Mr. Ghosh.
I have sought for instruction, my lord. Kindly give
What
me
instruction?
today's time, my lord.
Mr. Ghosh is opposing that.
No, for the petition, Lord, kindly see the matter is very simple. Your lordship decided the matter earlier occasion, and your lordship directed the district magistrate to decide, Lord, the way leave and other things. Lord, everything has been done. They have given a quotation of 10 lakhs and odd. Lord, we sought for a clear clarification that whether the earlier deposit of 4 lakh and odd that has been adjusted as directed by your lordship, and Lord, the manner of calculation on the basis of the formula which have been applied and break up. They have not provided, Lord, the same thing has been sent. That is our grievance now.
You wrote to them which page?
Lord,
Where
your
is that communication annexed?
Lord, page 79, this is the quotation.
No, where is your communication?
Page 80, Lord, and their reply at page 81 to 82.
What is the reply? They won't give it.
Now they say that same thing has been sent again. Without breakup, without Lord clarifying the position, and they ultimately, Lord, by later dated the advocate's letter, we simply sought that you provide this. Your lordship kindly come to page 84. Under such circumstances, I would request you to provide item-wise cost for laying and drawing underground cable, cost of materials, and the formula you have followed for calculation of the cost and rates taken into consideration for the supply of the load as applied for, indicating the West Bengal State Electricity Board Company Limited procedure. We sought for more as yet, nothing has been done.
So they had to provide those details.
Yes. And Lord, because the regulatory commission, Lord, has given some stage
guidelines.
Yes. They have not disclosed. This is our grievance now.
But virtually the billing dispute, because we have.
No, they're not disputing the bill. They're saying that they're asking for you to give the breakups.
We we have given the provided, he is not satisfied.
Where is that?
Kindly see his own.
But that is not by system I have given. That is not page 79. We have given. No breakup, no procedure, nothing. That's why we made a representation that please provide us.
No, page 82 is probably their breakup.
No, they are 17, page 79 first. No,
Page
can see?
79.
79 is the first one.
First one and second one, Lord, after this letter, they provided the same thing.
Oh, yes.
Identical.
It's not a breakup.
Ah.
This is a breakdown sort of.
We are normally providing this for the purpose.
Give the breakup. What is the difficulty? Give the details breakup and whatever you cannot account for, give it under miscellaneous.
And Lord, your lordship directed the adjustment of 4 lakh and odd.
This cannot.
That has not.
What cannot be done?
What Mr. Senior friend is saying, adjustment, because kindly see his writ petition, my lord. He is asking for breakup. Now, according to us, we have given provided the breakup. If he is not satisfied with the breakup, now, my lord, it will be go to the ombudsman.
Where is the breakup? The same thing has been repeated. Charges, GST not applicable in rupees is total. That is the only amount. The rest is 0000.
He is asking what cable he will provide, supply the number, cable number. Now, my lord, these are the things that. But that's why, my lord, I told them to.
Then it's a billing dispute, Mr. Ghosh.
Lord,
details of the cables and all the companies of the cables, they are not.
Lord, they have given it. They have quoted, provided the quotation, Lord, but not clarifying it. And Lord, both the district magistrate and my lord directed them to adjust the father deposited 4 lakh for the same purpose.
Then it's a billing dispute, Mr. Ghosh. Go to the GR.
Lord, your lordship kindly see your
We
direction.
cannot calculate from here.
Lord, your lordship's direction. That amount.
That has to be complied with by the GRO.
Lord, the district magistrate also, Lord, in terms of your direction, decided the matter and directed them to adjust the matter. Your lordship kindly see whether.
Show me the relevant portion, Mr. Ghosh, of the order. Either the district magistrate or this court.
Yes, Lord. Yes, Lord, kindly come to page 72, last paragraph. Last part, second last paragraph.
Yes.
Whereas, considering the above facts and circumstances,
shall adjust the quotation amount.
what is
The
the
amount
amount
which is
already paid by the father?
No, Mr. Mukherjee, you have to do it then.
But
Won't you adjust the quotation amount?
But kindly see, my lord, our letter. But as per the order, my lord, what we have sent to them, kindly see page 73.
73? Yes, 73.
On reference to the WPA number such and such, District Magistrate Hooghly directed to provide the new electric connection by laying underground cable from the existing infrastructure situated across the concerned road by observing all the safety measures and in consultation with the concerned local municipality. In that respect, an inquiry was conducted at your premises and also the drawing was prepared. Therefore, you are requested to make arrangement by way of OA as per the order of the District Magistrate Hooghly and report to the undersigned.
That has been done.
Now, kindly see next page.
These are immaterial, Mr. Mukherjee. Don't get ready here.
What's
Where have you adjusted the amount? Show me the reflection.
amount has been increased.
Instead of adjustment.
Kindly see, my lord, that Mr. Ghosh knows.
No, I don't know. No, kindly, your lordship's order also.
Mr. Ghosh does not know.
But kindly see, my lord, because that's why, my lord, yes.
No, Mr. Mukherjee, I'll direct your client to give an exact breakup of what is the actual amount you have estimated, and after adjustment, what is the amount.
Lord, your lordship's also, Lord, kindly see page 58.
This is sufficient. 72,
Yes.
the district magistrate is sufficient.
My lord's order also reflected.
District magistrate after that has given this. Learned counsel for the petitioner contends that despite an order of this court and the district magistrate, Hooghly, pursuant to the order of this court, the distribution company has not reflected in its estimate the adjustment of the quotation amount which has already been deposited by the petitioner to the distribution company. First up, when the petitioner sought for detailed breakup, the WBACDCL merely reiterated its previous estimate, which does not disclose any breakup whatsoever. First up, next para. Although learned counsel for the WBACDCL is somewhat justified in submitting that the exact breakup of each and every component of the estimate cannot be given, since it would entail extreme complications, if the same is to be given for all the consumers, the petitioner is justified to the extent that the WBACDCL is required to reflect in its estimate as to what was the quotation amount paid by the petitioner and the amount now estimated by the petitioner, and give an adjustment to the quotation amount already paid in the final amount payable. Full stop. Accordingly, a fresh bill in such regard shall be raised by the petitioner. I'll dispose of the writ petition, Mr. Ghosh.
Yes, Lord, what is the procedure they have followed, Lord, for calculation? That must they provide.
Need not.
Lord, because there are, Lord, 10A, 10B. There are two procedures.
Accordingly, WPA number 14528 of 2023 is disposed of by directing the WBACDCL to issue a fresh estimate to the petitioner within a week from date, indicating the exact amount estimated at the present juncture by the petitioner, and also reflecting the adjustment given of the said amount with the quotation amount previously deposited by the petitioner. Full stop. Next para. However, it is made clear that it will be open to the petitioner, if aggrieved with the quantum so raised by way of estimate by the WBACDCL, to approach the concerned grievance redressal officer for resolution of the said dispute. Full stop. Nothing in these orders shall preclude the petitioner from so moving, nor as to cause urgency report. Thank you.
Lord, if they provided the system generated quotation, then there was no given, because they have not given it is handwritten. And
If they have to give the entire component breakup to every consumer, Mr.
No,
Ghosh,
Lord,
it will
that
be
is
very
not.
difficult.
But Lord, up to certain limit there is rate.
Should be.
That's why,
But that limit cannot be decided by the writ court.
No, I am not saying so.
So then you will have to go to the GRO.
Yes.
So I've given you that limit.
Lord, you will also direct them to provide system generated quotation. That will do. Because
Quotation we will provide.
So Mukherjee decides the system.
No, they are through computer. They are
System generated means Mr. Mukherjee generated. So ultimately, you will have to go with him.
with my lord's.
15. Yes. 15. Yeah, for the
But I object for the respondent number 1 only, not the second appellate authority.
By only the allegations are against the other respondents.
I mean, they have allegations against all the respondents.
Yes, what is your allegation?
15 and 16 and taken up to
15, 16 though. Duty board dekhi. Please take the microphone.
pertains to non-furnishing of information
Switched off.
of the Right to Information Act. The petitioner appeared in the recruitment examination of Group D staffs of Murshidabad Judgeship. The examination was held in March 2019, written examination. Thereafter, the petitioner has no information regarding publication of result of written examination and the date of IOC examination. The petitioner addressed an application under Section 6(1) of the Right to Information Act, seeking certain information in connection
You
with
have served on all?
all.
Very well. Yes. Affidavit of service you have filed.
Yes, and another matter I'm filing, Now,
Let's continue from where you left. Yes.
Now,
Then what happened?
without receiving any information, the petitioner has preferred fast appeal.
Right.
Under Section 19(1) of the Right to Information Act, the order of fast appeal,
District Judgeship of Murshidabad is required to be present, since they have
They have been
rejected.
impleted.
Yes,
the order of
If impleted, if they choose not to appear, what can you do?
The
they have
order is at
rejected
page
their
32.
application.
The order is at page 32. The crux of the order is the information which I am seeking is personal in nature and that could not be entertained. They are challenging that order. We have preferred second appeal before the West Bengal Information Commission. Thereafter, no response.
From whom? The
From
second
the-
appellate authority.
Second appellate authority. And the order of first appellate authority.
So
is
then the
at page
second appellate authority has to decide on it, on merits. When did you file the application? The
Very
second?
recently,
in the month of May.
May 2023.
This is premature.
Well, second appeal was defunct for 1 year, at least.
The bench.
Huge bench, yes, lordships. Only one bench is available right now, So we are taking up the matter filed in 2022 January even. And the first appellate authority has passed a very recent order. They have said 4 to F, query number 4 to F are available in the website. That is in the public domain itself. And so far as the G is concerned,
F are the results.
4 to F of the query.
Those are the results, regarding the results, general results. Why available on the website? Must be pertaining to
information-
the results of
My
that exam.
information, is at
4 to E, lordship, and 4F is the public third party information restricted under section 8.
I can only direct the second appellate authority, but if you have filed it in May only, they are hard pressed.
My lord, only time bound limit.
No time bound.
Well, we will take up all these matters serially.
I'll only express an expectation that it will be heard expeditiously. I cannot do it within a time bound frame. Learned counsel for the petitioner submits that the petitioner appeared for a Group D examination in the judgeship of Murshidabad. Subsequently, certain relevant information according to the petitioner, were sought by the petitioner. In view of a part of the said information being refused by the first forum, the petitioner preferred. Oh no, you got that information. They preferred the appeal before the first.
No.
You. আচ্ছা যেটা বলছিলাম সেখান থেকে কন্টিনিউ
First appellate authority dismissed the first appeal.
The petitioner preferred a first appeal, which was also dismissed on merits. Full stop. Against the same, the petitioner took out a second appeal before the appropriate authority, which has been kept pending. Full stop. Next para. Despite service, none appears for the respondent numbers
2 to 4.
2 to 4, although the respondent number 1 is represented through counsel. Full stop. Learned counsel for the respondent number 1, for the sake of information, indicates that the application of the petitioner was filed only in the month of May this year, that is the last month, and that the second appellate authority was defunct due to lack of presiding officer for about a year. Full stop. However, it is submitted that the pending matters are being
taken up serially, Lordship.
Taken up serially, and an endeavor is being made to dispose of the same as early as possible. Full stop. Since the petition has only been, since the second appeal has been preferred by the petitioner only in the month of May last, any time-bound direction in the present writ petition shall be rather premature. Full stop. However, WPA 14550 of 2023 is disposed of with the expectation that the second appellate authority shall decide the pending second appeal of the petitioner as expeditiously as the business of the said forum permits, preferably within 3 months from date.
Grateful, Lords. Same order in the next matter, only 2 separate orders.
2 separate order, আলাদা করে same order.
Grateful, Lord.
Thank you.
Grateful.
No, that is also regarding this judge.
Applicant is different only.
Thank you.
Grateful, Lord.
17.
Well, I am for the petition in this matter, my lord.
Yes.
My lord, I must say, my lord, that there is a private respondent, my lord.
Oh.
Though her, my lord, that has been returned with, my lord, remarks addressee moved. Though her presence was not necessary, but to show my bona fide, I made her party. Kindly allow me to move my writ petition if my lord will deem fit to, my lord, that she needs to be served, my lord.
File your affidavit of service in India.
My lord.
Main allegation against the state. Against the respondent.
Yes, my lord, against the state.
Very good. What is the matter?
My lord, I am a octogenarian, my lord, aged about 88 years. My lord, I have made a deed of family settlement, a registered deed of family settlement, my lord, in favor of my daughter, with a view that she will take care of me. My lord, I reserve my right that I can, my lord, cancel it. Even, my lord,
Reserved in writing in a clause of the.
Yes, my lord. Even, my lord, the contents would show that for all practical purposes, it was a will. Because, my lord, it was said that it will be affected after my death. Thereafter, my lord, my daughter started inflicting torture upon me for selling that property. I decided to cancel it. Now, that is being refused by the registering authorities.
Registering authority cannot allow it. How can they?
My lord,
registering authority they will allow it.
My lord, of a subsequent deed.
Move the appropriate forum under the concerned law.
No, my lord, my lord, I intend to register a subsequent deed for cancellation of that. It's not, my lord, I understand, my lord, that is not coming under the purview of, my lord, Senior Citizens Act. My lord, this is, my lord, this is not even a gift. Kindly consider, this was a will.
Registration office cannot decide that. If it's a registered document, the effect of that, you can file a suit for that. You have to file a suit, or your best remedy probably is before the senior citizen.
May I say, my lord,
that
under the law, even, my lord, I am not required to cancel it if it is a will.
Don't cancel it.
In nature, my lord, but the practical,
infructuous,
my lord, the practical purpose which I am facing, my lord, that since, my lord, now, my lord, I want to divest that property in favor of someone else, my lord. That person is having problem because of this deed. My lord, kindly considers, my lord, I can show from the contents, my lord, only 2 paragraphs I'll show, which would, my lord, show that for,
Registration authority does not have the authority.
no, it's only for registration of that document. It's not that, my lord, I'm asking them to decide it.
Show me that document once.
Yes, my lord. My lord, it's starting from page 13. My lord, kindly comes to page 18. This was the registered one. Page
How
18.
will this be classified? This is not a transfer deed.
No, my lord. This was
You're
said by
transferring it
Parivarik.
in your favor again.
Yes, my lord. Parivarik Bandobast Patra. Now, kindly see, my lord, page 18, my lord. I'll
page 18, yes, I'm
yes,
there.
my lord. 1, 2, 3, 4, 5, 6, my lord. 8 line, my lord. Amar Mrityur Par. Page 18, my lord. 8th line.
Yes, why can't you register it? If you don't have the authority to decide its veracity, either way, then it has
No,
to
my lord,
apply.
subject to correction, Lordship may kindly see section 72. First of all, no document is annexed in the writ petition to show that the concerned authority has denied. That is his prayer. He is seeking mandamus that the authority has refused to register. So his remedy lies under section 72. He can prefer an appeal. For that, writ court, why the writ court should interfere, my lord?
The, my lord, age of the
Section
petitioner,
72
my lord,
is very specific
that he
and
is
clear.
bedridden, my lord, and anytime, my lord, kindly considers that fact, my lord.
It is sponsored by the person who wants to get the property now. So don't show the age of the.
No, my lord, if this person dies, my lord,
then your client, your sponsor does not get the property. Obviously, this person has not come up before this court as a name lender. So
No,
don't cite the age as a sympathy.
no, my lord,
brownie point.
that's not the. But it's all about his wish, my lord, that he.
Learned counsel for the petitioner submits that the petitioner seeks to cancel a deed previously executed by him, which, in any event, the petitioner is entitled to cancel under the law. Full stop. However, the registering authorities are refusing to register such cancellation deed, for which the present writ petition has been preferred. Full stop. Next para, learned counsel appearing for the state respondent contents that the petitioner has a remedy under the concerned statute to go up in appeal in the event any refusal took place. Full stop. In any event, it is submitted, there is nothing on record to show that the registering authorities have refused to so register the deed in any manner whatsoever.
I made representations thereafter, my lord.
Full stop. It is seen from the annexures to the writ petition that certain representations have been given by the petitioner. Full stop. Anything to show that you have presented this for registration at all?
Lord, I have said so, my lord. That has not been denied by the authority still now.
Any refusal
Lord,
subject to
that's
correction
not
has to be entered in book 2.
So next para. However, mere representations do not suffice insofar as the procedure regarding registration is concerned. Full stop. In the event the petitioner seeks to register the document in question, the same has to be presented before the before the registering authorities in due course of law. Full stop. Accordingly, WPF 14556 of 2023 is disposed of by granting liberty to the petitioner to present the document in question for registration in due process of law before the appropriate registering authority. Full stop. If so presented, the said authority shall process the said application of the petitioner for registration and take a decision in accordance with law thereupon. Full stop. Such exercise, it is expected, shall be undertaken as expeditiously as possible and shall be concluded preferably within 3 weeks from the date of making such application by the petitioner. Probably it's lesser than 3 weeks now after this computer system. It may be done in 2 days also. Anyway.
Grateful.
Thank you.
18 is my application. The main respondents are respondent number 2 and 3 upon which it has been served. Now, the first respondent is union, but it has no basic role. The issue is very small. Once upon a time, I had taken a loan from the bank by mortgaging my 4 tea gardens. Now, those 4 tea gardens in 2011 were under the scheme of demerger were hyped up to 4 different companies, and accordingly, when the property shifted, the charge also shifted. Now, those 4 companies, no due certificate I have annexed, page 179 to 182. Those 4 companies, which were 5% to the order of demerger. Lordship, there are Naya
Next,
Sai.
all those.
No, for 179 is the first one, Naya Saili Tea Estate,
Yes, yes.
and 180 is Saili, 181 is Dalmo.
So all of them are there.
All of them are there. Now, what has happened, my lord, there are some mistakes on my part also. If your lordship comes to the master data of my company, which is at page 183. My lord, what has happened? This company is Octavius. Before 2007, it was with the Padma Kanoria Group. Now we are now representing the Jain family. The Jain family, under the share transfer agreement, took control of this company in sometime 2007. Now, when they took over this company, immediately after they took over this company, there was an infighting between the members of the Jain family itself, which started in 2013, which is still continuing to some extent. The awards are also here. Now, what happened, Lordship, see 183, there are very old charges which have been shown in the master data, continuing from 1977 onwards. Now, today, all the charges are satisfied because nothing is now earmarked for Octavius. Now, when we write to the concerned bank, which was earlier United Bank, now after the merger, it is Punjab National Bank. Now, because of the documents, for purpose of satisfaction of charge, we have to file certain documents. That time period expired because under law, lordship, for satisfaction of charge, we have to file certain documents. Now, that was because of the past history of this company, my lord, those documents were not given at proper time to the bank. Now, good, bad, indifferent, they are showing these charges. Though technically there is nil charge. We have written letters to the bank. Lordship, one of the letters is page 107.
Direct a short affidavit to be filed because they're not a, or if you prefer, you can give another notice and come back if it can be resolved. I mean, these charges, they'll have to take instruction.
Now, what is the procedure? ROC says that, but not says directly as per law, they will act if the the documents have been given to them within a period of time, then only
they have not done that.
We could not because we are in the process of legal tangles going on. We are
there any process of condoning it? I mean,
yeah, because basically it's a lordship. Now we have come to a lordship for the exercise of powers under Article 226. My lord, if the bank has no dues,
you have to ask for that condonation before the authority, I suppose.
No, authorities, my lord, lordship sees my last representation, which is on 19th May, which is at 2:45. If this also we wrote to the bank. Now, please give us the NOC for release of charge and mortgage. Now, bank has not given any reply to this. Now, unless the banks gives us the NOC, we cannot give the NOC to
you have to submit the documents before which authority?
Register of companies. Once we get from the bank.
Achha.
Now, bank is not giving us the main primary of the respondent in the bank. We can give them another notice and come, my lord, on Tuesday, lordship.
I think that will be better because that can resolve the
this
immediate issue.
Because they don't have any money for me. Even those 4 companies have cleared off. So it is just a procedural thing which has created the hiccup. Now, when I go now, for me, what is difficulty when I go to the another bank for taking loan, they are getting scared. You have so many charges, we will not give you any loan. So my entire business expansion has come to a stop.
Learned counsel for the petitioner submits that certain old charges have been reflected in the records, although the concerned companies have already given no dues certificates to the petitioner company.
And we also do not owe anything to the bank.
It is further submitted that the petitioner company also does not owe anything to the respondent bank, that is the Punjab National Bank. In such perspective, the petitioner wrote to the PNB regarding issuance of an NOC with regard to release of charge / mortgage in respect of assets and properties of the company. However, the bank is sitting tight over the matter. Since the matter may be resolved without inviting affidavits, the learned advocate on record for the petitioner is requested to serve another notice to the respondent number 3, indicating that the matter shall be listed on April 4, 2023 to avoid this comment list.
And also monthly list.
Pardon?
Monthly is coming on 3rd.
That's why I'm putting it on 4th. On April 4, 2023, when the matter shall next be listed fairly at the top of the list.
No, next month. 4th July.
July 4th.
4th July.
Sorry, 4th July.
And we shall come with an affidavit service on that day.
Please do. I've not recorded
Yeah, I
that.
know that. We shall come.
Even if it's a receipt, I mean, on
Yes,
their
yes.
advocate, whatever mode, just serve them. We want their presence on that.
Hand service, we shall also do hand service also.
To the advocate, that will be better.
Advocate,
Whoever
we don't
appears.
know, we don't know. As of now, nobody has turned.
For PNB, excellent.
You are there.
Serve it on Ms. Rachudhuri and
That is great.
you give a formal writing that you have instruction to appear for the bank
Yes.
so that they can give this. Thank you so much.
Yes.
Thank you. Yes.
19.
19. Yes. Yes, Mr. Bhattacharya, what is the matter?
Which you appear for the respondent.
You're for the private respondent.
No, my lord, bank. For the respondent bank.
State, yes. Petitioner.
The private respondents, my lord, the intimation has come back with door locked.
Door locked.
They are not traceable. But there is a reason why. My lord,
The private, what is the dispute?
I tell you, lordship, lordship. if
They are
your lordship-
necessary here.
Yes, my lord, kindly comes to the cost.
So serve them properly then.
My lord, can't be. They, my lord, what happened, my lord? They have taken, my lord, kindly see the cost title. Who is the
Use the microphone, Mr. Bhattacharya.
who is the petitioner? Kindly see. The municipality is the petitioner. Now, my lord,
Yes.
kindly comes to the next page. The respondent number 5. Landmark Construction Company. Now, my lord, we entered into an development agreement with this respondent number 5, you know, for construction of a market. Now, my
All
lord,
of them are not there.
all of them are not there. Now, my lord, what happened? This respondent number 5 took loan, my lord, from the respondent number 4. Now, my lord, and the respondent number 6, 7, and 8 are guarantors. Now, my lord, as usual, my lord, loan default. My lord's proceedings in DRT. Now, my lord, kindly see page 40.
Yes. 40.
My lord, this is the possession notice, my lord, which my lord, municipality, this notice we are challenging, my lord. This is the land belongs to municipality. My lord, showing the lease deed, my lord, which was executed by municipality with the respondent number 5, the loan was obtained. Now, my lord, the land of the municipality, my lord, is going to be taken away. But the possession, which is the possession notice.
So you have your remedy before the tribunal.
No, my lord, remedy is if your lordship would kind enough to come to section 31 of the act.
Surface.
Surface. Remedy, my lord, I know, my lord, section 17, my lord, for unnecessary, my lord, I have to deposit this.
Why unnecessary?
My lord, but first of all, my lord,
Municipally has extra incomes also.
no, my lord, the councillors may have municipality as a corpus, my lord, they are always. And that kindly, if the
Contact Mr. Roy Chaudhury's family. Srirampur municipality. No, you have a remedy.
The my lord, kindly
Why
appreciate.
bypass that remedy? This will open a floodgate, proverbially.
Kindly, my lord, very well, but till
It is
that
2
time,
versus 1. They're both nodding their heads. So
and the kindly, my lord, kindly sees the 31, the provision
31,
of
yes.
this act shall not apply to, kindly comes to, my lord, E. 31, my lord.
Oh, I'm sorry.
Miscellaneous.
Even
It's
that's
under
okay.
chapter 6. I'll hand over my.
No, I have a copy. E.
31, my lord. Yes, my lord, E.
Yes, E.
My lord, this provision of
E has been deleted probably.
E has been deleted.
Substituted for. I'm sorry, 1. This is clause E omitted with effect from September 1st, 2016. I don't know whether this book is correct. This is
Mine
LexisNexis.
is also, my lord, the same
Universal.
book, my lord.
Universal LexisNexis.
Oh, no, it's universal, my lord.
What is the year of that book here?
Here, my lord, 12, my lord.
22.
Perhaps, my lord, what is troubling my learned friend is the fees, I believe, is what is
Definitely,
troubling.
yes.
If he has
My
to
lord,
pay-
section
Definitely.
17 provides that there are categories for which the fees are prescribed differently.
Right.
He comes under the any person aggrieved.
Yes.
So, my lord, in that case, the fees which he has to pay is not equivalent to what is what has to be paid by the secured creditor.
Well, any person include, it says including borrower, my lord, borrower can.
Section 17.
Yes,
yeah,
yes, 17, yes.
There's a proviso. That proviso provides that it shall be, the fee shall be assessed differently.
Yes. That
Well,
has been done.
No, my lord.
No, my lord,
My lord, there are two things.
No, that has been done means the prescription, the something has been prescribed.
Yes, no, nothing has been prescribed. My lord, that is that table chart, they have it there, but it is two different categories.
my lord, only thing, my lord,
That cannot be a consideration.
my lord, I will
You have a remedy in law,
definitely I will, but by that time, my lord, it's municipality's land. It's municipality's land, my lord, possession notice may not be given effect.
No, no, no.
My lord,
Municipality
kindly,
is
my
not a
lord,
favored
I-
duty.
no, I don't say, my lord, we are not at our fault also. This was done entirely, my lord, behind our back. We did not have any knowledge.
Your fault is that you are a juristic person coming within the purview of Service Act.
I bow down to your
That is
lordship.
your fault.
I bow down to your lordship. But till that time, my lord, this
I have to bow down to the statute.
my lord, kindly,
Bhattacharya, there
kindly
is a remedy.
appreciates, my lord. This is, my lord, a bazaar. This is a marketplace, my lord. Kindly appreciates, my lord. For this, my lord, the agreement was entered into.
So what interference are you expecting?
No, my lord, till the time, my lord, I get some interim protection from the tribunal. This, my lord, possession notice may not be given effect to.
Interim protection
My lord,
was already
kindly appreciate-
granted.
my lord,
Courts cannot give that under the Act.
my lord, kindly
And under
appreciates,
settled
my
law.
lord,
It has been
kindly-
long back, settled long back.
Definitely, but kindly appreciates for no fault of the municipality, my lord. It was
No fault of the municipality is not something so perverse, no patent, not something so patent that we have to interfere.
my lord, our
This will
my
open a
lord,
floodgate.
lease deed, my lord, showing it as a title deed. It was deposited by the
Whatever.
respondent number 5 and 6, 7, and 8 are guarantors.
Learned counsel for the petitioner submits that
Only one thing, my lord. Only before kindly come, if your lordship kindly comes to page 10, my lord, the lease deed.
page 10.
Yes, my lord. 25. So I'm extremely sorry, my lord. 25.
10 of the lease deed, acha, internal page.
Part of, yes, my lord.
Page 25,
17.
yes.
If your lordship kindly comes to clause number 17.
Which has been underlined also for me.
I'm sorry, my lord.
No,
The
it's-
sword said loan.
This is a photocopy.
Yes, my lord. Kindly see, my lord, that the lessee shall be entitled to develop the said market complex with the financial help of the bank, private financial institution, LIC, etc., for which lessor shall give its consent, but for the loan of the lessee, the municipality shall have no liability whatsoever. This was agreed upon, my lord. That is the
Estoppel against statute.
Lord, this was agreed upon, my lord.
Between you and me, we
ultimately-
agree that I'll not be bound by some law.
Well, ultimately, it is my lord, the municipality's land, which will be ultimately used for public purpose and which was intended to be used for public purpose.
No doubt on that. Definitely municipality, yes, it is working for the public, supposed to work for the public at least. No, we cannot have any converse presumption also. But here you are bound by the law. We can do nothing on that.
But only
If you have to pay some amount, you have to pay.
definitely, my lord.
Public money I appreciate, but nothing doing.
I will approach the tribunal, but kindly limited protection. It may not be, my lord.
If that is granted, then it will open a floodgate and it will be the norm for every other case. Why refuse others? Then Article 14 comes in.
My lord, then my lord, some my lord, liberty, my lord, so that I can.
Liberty to approach the appropriate forum.
But dismissal will not be a.
Very well. Not what you are asking. Learned counsel for the petitioner contends that the municipal property is sought to be taken possession of by the bank
Under Rule 8 of the.
for alleged non-payment of a loan by the private respondents, with whom the municipality merely entered into a development agreement.
Not all, my lord. Not all. Only 5. Only
Achha,
5.
private respondent, private respondent number 5.
6, 7, 8 as guarantors to
The
the.
next para, it is submitted that as per clause 17 of the said agreement between the municipality and the developer, the municipality has no liability whatsoever for any financial help taken by the developer from the bank, private financial institutions, etc. For next para, it is thus submitted that in view of the patent rights of the municipality, which ought not to be affected by the loan taken by the developer, the municipality has a relief against the possession notice, which has been impugned in the present writ petition. Next para, at the outset, learned counsel for the respondents take a preliminary objection regarding maintainability of the writ petition, comma, in view of availability of an equally efficacious alternative remedy in the form of an application under section 17 of the SARFAESI Act 2002 before the appropriate tribunal. Full stop. As regards the I'll not record anything on the court on the duty. Let that be as it is. So next para, upon a consideration of clause 17 of the agreement in question, comma, it is evident that a private treaty between the parties cannot have the effect of creating any estoppel against the statute, full stop, since the law is very clear that remedy of any person aggrieved against any action taken under the SARFAESI Act is before the tribunal, comma, there is no exceptional occasion in the present matter to interfere in the present writ petition. Full stop. Accordingly, WPA 14632 of 2023 is disposed of with liberty to the petitioner to approach the appropriate forum in due process of law. Full stop. Nothing in this order shall prevent the petitioner from making such an application before the concerned tribunal. Full stop. If so made, comma, the tribunal shall decide the same in accordance with law without being influenced in any manner unduly by any of the observations made herein. No rest to cause,
In case of the coordination of delay, that might, my lord, may be independently dealt with by the tribunal.
I've not said anything on that. I've given them liberty to approach in accordance with law. That's why that has been introduced there. Thank you.
Lord, kindly to mention a matter only for the purpose that the matter was heard on 22nd, notes were given on 23rd. The urgency was the sale is on Friday. Your Lordship will recall that City Star matter, SBI.
City Star order, that is original side.
No, appellate side, Your Lordship.
It's the judgment is ready.
Your Lordship only.
City Star order pass kori.
Kindly don't take me amiss, Your Lordship. I would not.
No, no. Why should I take it?
13667.
City Star, yes, City Star. One was City Star, the other is
There was Sean Automobile.
Sean, yes.
22 তারিখ hearing শেষ হয়েছে 23 তারিখ
Definitely, I'll pass it on 30th. On 30th, yes.
My lord,
CV to হয়ে আছে আমার judgment to dictation হয়ে আছে. Anyway, I'll check up. I'll definitely pass the order on Friday. In the first hour, the first thing.
my lord, my senior mentioned this matter, and after that, that was allowed by your lordship.
I'm
Now-
sorry for the delay. I mean, I missed out. I have passed the judgment. I remember I have dictated my order, but it should have been delivered today. I'm sorry for that. Yes.
Lordship, now today you will be rising on at 3 p.m. Lordship. My senior mentioned this matter, and that was allowed. Now tomorrow is holiday, my lord. Now tomorrow is the sale. Auction is scheduled on tomorrow.
What did
my
I
lord.
allow?
You have allowed for the hearing, and this is running on item number 31 for today's list.
Today morning, this morning I have mentioned.
No. It was earlier mentioned.
Whatever. Nothing doing. Let us follow the list. Yes.
May I be permitted to seek leave for filing, my lord?
At this hour, no. Come back on Monday.
Friday. Great.
Yes, Friday.
Great.
Item 20.
May I appear for the petition as well?
Yes.
May I handle the evidence service in this?
Mr. Ahmed, you have served. All have been served.
The private respondent is there, my lord. Says, my lord, the
Please use the microphone, Mr. Ahmed.
The private respondent shows, my lord, he has not been affected, my lord. Service has not been affected.
You
upon
have
him,
to
my
serve him and come back. Service is not yet complete on the private respondent. Full stop. Accordingly, let the matter stand adjourned till July 5, 2023. 5th July. Next Wednesday.
Lord. 21.
Yes.
Lordship, I'm appearing for the respondent bank.
Lordship, I am for the petitioner.
Right.
Respondent number 3.
Right. Yes, what is the matter? Let's
Lordship,
take your seats for the respondents. Yes.
Lordship, fact in nutshell is that the surface application was filed by the petitioner and being aggrieved with the application on 23rd September 2022, an appeal was filed. On 1st March 2023, the order of the appeal was passed. Appeal was dismissed because right of the parties was not determined yet, and with the direction that tribunal should dispose of the matter within 15 days, preferably within 15 days. I have annexed the order. Subsequently, on 6th of March 2023, an order was passed for taking physical possession. 7th and 8th was holiday. 9th, on the first morning, first sitting, I have mentioned before Honorable Justice Bhattacharya, leave was granted and matter was filed on, matter was fixed for 23rd March. In the meantime, what happened? Bank has taken the possession on 9th of March. My point is that till date, the tribunal has not heard the matter yet. Till date, which was ought to be heard within 15 days.
Show me the division bench order directing the tribunal to do it.
Division bench, not the division bench, but the tribunal.
Show
Appellate
me that
tribunal.
order. Yes.
Relevant page is 132, my lord. Just above the ordering part. Preferably within 15 days.
Where is that direction? Preferably within 15.
My lord.
Oh, acha. Before the ordering.
Yes, just above the ordering portion.
So you want that direction to be reiterated? What else can be done at this stage?
Lordship. Because already bank has raised the point of maintainability. I have filed the restoration application over there. Nothing has been heard. Even on 28th of March, I have mentioned the matter before the tribunal. I have annexed the order on 28th of March.
Well, I'll pass it. That is in.
My lord, it is
For expeditious hearing, I'll not stand in the way.
fix a time period, my lord.
Very good. Learned counsel for the petitioner contents, comma, shorn of unnecessary details, comma, that a dispute raised by the petitioner went up to the appellate tribunal, wherein an order was passed on March 1, 2023, directing the presiding officer, comma, DRT Siliguri, who is link officer of DRT2 Kolkata, comma.
My lord, subject to correction. Subsequent to that, 3rd March, another order was passed that DRT1 will hear the matter because DRT3 was not joined at that time.
On page number 134.
Page number 1.
Which sentence I continue? Thank you. As expeditiously as possible, preferably within 15 days, comma, which was modified subsequently by the order dated March 3, 2023, recording that the presiding officer of DRT1 Kolkata had taken over charge of DRT2, comma, and transferring the proceeding to DRT1 Kolkata, comma, the matter has not yet been, the matter has not yet been decided by the DRT3. So it is contended that the petitioner was evicted from the disputed property as long back as on June 9.
No, 3rd March 9.
On March 9, 2023. Next para, it is submitted that hence the petitioner is suffering inordinately. Next para, heard learned counsel for the parties. In view of the innocuous nature of the prayer, comma, no affidavits are being directed. WPA 14764 of 2023 is disposed of by directing the DRT1, Debts Recovery Tribunal 1, Kolkata, to dispose of the petitioner's appeal, dispose of the petitioner's application being MADY number, that is
no
TSA 1
TSA 1 of 2023. Transfer surface application number
Page number 146, your lordship.
Page number 146.
in the prayer portion. You have not mentioned it.
My lord.
No.
My learned senior friend has no prayer.
No.
Of this.
No.
Page 142.
146.
146. 145 and 146.
Being TSA 1 of 2023, pending before the said tribunal, as expeditiously as possible, comma, positively within July 21, 2023. The parties as well as the tribunal shall act on the server copy of this order, coupled with the communication by the learned advocate for the petitioner for compliance of the same. No rest to cause urgency.
Grateful to your lordship.
I've given him 3 weeks approximately.
Lordship.
Grateful.
22.
May we please your lordship, I am for the petitioners.
Yes, please.
Affidavit service be kept in.
Well,
the
I am
record.
for the
I have served
state
all the
respondent, my lord.
respondents.
All have been served.
Sir,
Yes, what is the matter?
my prayer before lordship, this is the petitioner's property. But it is very much in luck to the petitioners that the respondent, particularly respondent number 10 and 11, in collusion with the electricity department, one post was installed in their own premises. This is the purely Rayat property. Earlier occasions, so many times.
In their own premises means your own premises.
Your own, mine, ours.
Very well.
Earlier occasions, that is since 2020 till date, petitioners prayed everywhere. Not only that, in this regard, petitioners moved an application 144 CRPC before the executive magistrate Diamond Harbour. Order was that they got the interim order of injunction. The petitioners sent all the orders to the respective authority. In spite of that, the HON'BLE Pradhan, respondent number 10, respondent number 10 is the member of the Panchayat Samiti. His wife is the HON'BLE Pradhan. 11 is the member of the Panchayat, Gram Panchayat. So my respectful, not only that, after getting the petition as well as notice, yesterday they have cut off their electricity line. How it is possible? Earlier occasions also.
Whose electricity line have they cut off? Your electricity?
Ours. In this regard, petitioners.
No. There are two allegations. One is that they installed their pole on your property.
Our property.
But that was being used not for your giving connection to your property. That was being used for private respondent. And now your connection has been disconnected.
Disconnected yesterday.
By whom?
By the said fellow. Respondent number 10, 11, which I mentioned. So my first my respectful submission, Your Lordship, direct the respondent number 5 and 6 to restore. That is, they may get the.
Have you applied for restoration?
My lord.
Have you applied before them for restoration?
Yesterday I have gone there, but they did nothing. So in this regard, petitioners, one GD was also lost. Not only that.
But that is a private dispute otherwise, apart from the electricity.
No private dispute.
Electricity connection, if somebody else disconnected the electricity, the WBSEDCL has not disconnected.
Yes, my lord. The West Bengal State Distribution Company Limited is in collusion, my lord. Otherwise, how they will do it?
Yes, Mr. Naik, what do you say to this?
My lord, my instruction is this only. Yesterday I have got it. My lord, here 10 persons made application for new connection. 10 persons.
First of all, what about the disconnection?
Number that I have no knowledge because
yes,
that is not the prayer or also case.
That is the diary. Keep it with
you. He is saying yesterday night it is done. So
keep it with you.
Now thing is this, my lord, in presence of Pradhan, Panchayat and other people, my lord, inspections were made repeatedly, and on the, my lord, the brick road which is going inside, my lord, the poles have been installed on that, and my lord, 10 persons have been given connection. And that is
from that pole.
No, not pole installed.
No, what about the installation of pole on his land?
No, here nothing. My instruction is this: the poles have been installed on the, my lord, Panchayat land, and which is occupied by the government. No rioting.
Then you have to go before the district magistrate, sir.
My lord, lordship.
You have to go before the district magistrate for resolution of this. And regarding restoration of connection, if it has been disconnected, apply before the CSC, WBSEDCL. They will.
Your lordship, direct. We are in dark position.
We cannot direct unless there is an application by you and you comply with the formalities.
It was after getting the petition as well as notice.
It is not even on record. I cannot take whatever you hand up just because you have lodged a diary to yesterday.
As because yesterday they have earlier occasion they have also disconnected my line.
Learned counsel for the petitioners vociferously argues that in collusion with the private respondents, the WBSEDCL has disconnected the electricity supply of the petitioner yesterday during pendency of the writ petition. Insofar as the original cause of action of the writ petition is concerned, it is argued that an electricity pole was installed on the property of the petitioners since long back, despite the specific objection of the petitioners. Although the petitioners gave several representations in that regard, nothing has been done by the WBSEDCL to mitigate the problem of the petitioners. Next para, learned counsel appearing for the WBSEDCL disputes such contention and submits that no complaint has been lodged with the WBSEDCL as yet by the petitioners for regarding restoration of electricity connection. Insofar as the pole is concerned, it is argued that the same has not been installed on the petitioner's property but on public land, and has been used for giving electricity connection to several others. Full stop, next para. Certain disputed questions of facts have been raised by the petitioners. Full stop. The question here is whether the WBSEDCL has installed an electricity pole on the land of the petitioner, and if so, whether the petitioners are entitled to any compensation for the same under the contemplation of the works of licenses rules, 2006, and or any other governing law. Full stop. Next para. Insofar as the second issue is concerned, the same is a subsequent development alleged by the petitioner, in support of which the petitioners submit that they have lodged a diary. Full stop. However, since no application for restoration of electricity connection has yet been made, nor has it been established as yet that the WBACDCL has a role to play in such restoration, no relief can be granted at this juncture regarding the same. Full stop. Accordingly, WPA 14815 is disposed of by
My respectful submission.
granting liberty to the petitioners
not to dispose of this matter. My respectful submission.
What should I do? Tell me. District magistrate has to do it. Decide.
Submit the report before lordship. Thereafter, lordship can dispose of.
Suppose a report is submitted before me. That will only delay your matter, your restoration of it.
Only my respectful submission. Your lordship direct the respondent authority.
I'll grant you liberty to approach the district magistrate with this problem regarding the other problem regarding poll.
I have already submitted so many documents.
Have you approached the district magistrate?
Lordship.
Where is that application?
Your lordship can see the. That's why I am coming.
Where is that application?
Lordship.
Show me, lordship.
I am showing the lordship. Lordship, can you see the. I'm coming, man.
One is at page 57.
Your lordship, can you see page number 57, my lord?
57 is an application. You are an advocate.
Well, I have submitted, my lord.
Submitted whatever you like. You file a representation, advocate's letter, that will do.
Not
You are
only,
the district magistrate.
not only that,
Tomorrow you will instead of filing a petition, you will file an advocate's letter before court.
not only that, my lord, your earlier occasion, I have also,
You have never filed any application before the magistrate. Show me one application.
I mean,
Show me one application before the district magistrate.
I want to try, my lord.
You are wasting time of court.
No, my lord, I am not wasting.
Show me one application before the district magistrate. Enough is enough.
My lord, you also can see page number 45 for a moment. I have already submitted. That's why I'm not wasting.
Page number 45, what is this? This is an application before the magistrate.
Lordship, your lordship can see page number.
Lordship.
Page number 40 for a moment, my lord. Lordship,
45, I'm there.
44, my lord, first. That's why I'm requesting you, lordship.
44 is not an application before the magistrate. It's a representation before the senior superintendent of the WBSEDCL.
My lord, serial number 7, my lord.
যেটা অর্ডার বলছিলাম পাস করছিলাম কন্টিনিউ করুন
My lord, my respectful submission. DM also I have submitted, my lord.
Dispose of by granting liberty to the petitioners to approach the concerned district magistrate with a proper application in accordance with law with the dispute regarding the installation of pole allegedly on the petitioner's property and connected prayer for compensation, if the petitioner so choose. Full stop. Upon such application being made, the district magistrate shall decide the same in accordance with law upon giving an opportunity of hearing to all concerned without being influenced in any manner by any of the observations made herein. Full stop. Next para. Insofar as the allegation of disconnection is concerned, the petitioner has not yet taken out any application before the WBSEDCL for restoration of such connection. Full stop. Hence, further liberty is granted to the petitioners to file a proper application in accordance with law and procedure before the WBSEDCL for the purpose of restoring the electricity connection of the petitioners. Full stop. If such an application is made in due process of law, the WBSEDCL shall immediately consider the same and restore the electricity connection if the same is within the domain of the WBSEDCL. Full stop. Next para. That apart, if the petitioners have any grievance against the private respondents, on any sort of allegation against the same, against those people, comma, it will be open to the petitioners to approach the appropriate forum, comma, either criminal or civil, comma, with such dispute, which will be decided independently in accordance with law. No address to cause urgent certificate. Call on the next matter.
Grateful Lordship.
Thank you.
23.
Yes.
When I am the petitioner, service has not affected my.
Service has not been affected. 7. Service has not been affected on the prayer of the petitioner. The matter is adjourned till July 5, 2023.
Twenty-four.
Yes. Namta nahi known. You are for the petitioner? Oh, you are for the petitioner. Yes. Right. What is the matter?
Well, the decision-making process of the respondent ECL is under challenge, Malad, on 3 counts. First, Malad, termination, which is followed by, Malad, forfeiture of my security deposit, as well as, Malad, blacklisting, for the debarring of, Malad, for future, Malad,
Hearing given to you?
Nothing, not at all. Now, Malad, for 1 year. So the decision-making process, Malad, comprises of 3 counts. Now, if before your lordship looks into the impunity, the particular the letters, the communication, basically there are 2 actions, 2 letters. May I just tell your lordship brief facts? But I participated in a e-tender, of the respondent ECL for extraction of,
be precise, because we have
of course,
there are so many matters.
Only, so far as for extraction of overburden and for excavation of coal and for transportation, etc. Now, I participated in the capacity of a joint venture.
Right.
The joint venture is a petition number 1, and petition number 2 is he's a constituted attorney. Now, so far as my bid is concerned, I was awarded as L1. There is no dispute. Now, there is a condition that while the aspirants, while intending to participate, they have to deposit the earnest money, which is a security deposit that has to be paid. Now, that was paid in the name of joint venture company, the petition number 1, which was paid by one of the partner of that joint venture, be the lead partner. Now, that was accepted, and according to that acceptance, I was also being successful with the other conditions, and I was being elected as a L1. Now, the condition precedent in the contract clauses is that, I have to deposit the performance security, the PSD money, within 21 days from the date of issuance of the LOA. There is one more fact which I have just missed.
Date of issuance of the
LOA, letter of award. That is why I said, there is one important fact that after declaring LOA, accepting my earnest money deposit in the name of a joint venture company being given by my lead partner. Because what I said, see, because that is the issue. They have accepted, declared me L1, and they have issued the letter of award. And the letter of award, coupled with the terms, the contract terms, it provides that within 21 days, I have to pay the performance security deposit, which is of a certain % of a awarded value. It also provides with a caveat that in the event L1 wishes, he can ask for adjustment of that PSD money with the SD money. Say SD money is of 5 rupees and PSD money of 2 rupees. So I can adjust those 2 rupees with the 5 rupees and I can pay the balance 3 rupees. Now, I exercise that option. I say that you adjust it. And so far the balance money is concerned, I paid some of the money. Now, this payment clause contains another caveat that after 21 days, the L1 can have another 14 days to pay the money, and the ECL will consider the same subject to case-to-case basis. Subject to case-to-case basis. Well, I will show that particular thing. Now, my lord, out of the money I have paid almost after adjusting, there was a balance left of rupees around 45 lakhs. To some extent, little more or less. Now, I prayed for an extension. There was another extension beyond 14 days. I didn't even pray that. I said, give me another 10 days, I will pay. The ground that I have cited, my lord, then my maternal uncle, or might be paternal uncle also, that is suffering with cancer. And there is no other person other than me. I have also disclosed the voluminous documents in second part of the writ petitions, my lord's brief. And I have to look, and there's a huge expenditure I have to control, and the total PSD money also comprises more than 1 crore, nearly about 2 crore rupees.
They were suffering from cancer before you participated.
Yes.
Then you knew that.
No. So far as cancer, he at that particular point of time, he was undergoing through some treatment. So I have to spend some money. So I said that very well, give me some time within that extended period, 14 days. Why I said that within that extended.
That's not a matter of right.
No, that's of course not a matter of right, but may I just say this? I said that kindly extend the time. I will pay them.
They did not give.
They have not.
Proceed further.
They have not replied even.
Achha.
They have not replied even. Within those 10 days, I paid the entire balance amount.
Right.
Now, my lord, all on a sudden, my lord, after 2 months, they have issued me a letter that we terminate your contract, we forfeit your SD money, and we also ban you because of the ground that you did not deposit the PSD money within 21 days. My lord, it would be a case that my application was rejected, prayer for extension was rejected.
That was not even considered.
And my lord, my payment of further PSD money, because I initially said that.
So you paid that balance money within 10 days.
Within 10 days.
That was accepted by them.
Yes. Now, thereafter, they make out a third case. Lordship knows, my lord.
That was accepted by them.
Yes, accepted.
Then?
Thereafter, they returned by issuing another letter saying that since those were issued by the lead partner, not the joint venture, so we cannot accept. So introduce a third ground. Your lordship is well aware of Mahinder Gill that you cannot supplement a fresh reasons.
Before Mahinder Gill, they have supplemented the reasons. Mahinder Gill is in affidavit. So the affidavit stage has not yet come. Before filing the writ petition, they have done.
They have sub. So their initial.
Only Mahinder, not Gill.
Only Mahinder.
Yes.
Well, so far as their initial contention was that, and my lordship, kindly, may I also add one thing. So far, the SD money is concerned, that was submitted by the lead partner, who is the constituted attorney of the joint venture company. That they accepted, they declared me L1, they issued me LOA.
The rest you don't have to repeat again and again.
And after that, what the PSD money that have submitted in breakup, that also was given by the lead partner in the name of joint venture.
Understood.
That they also accepted, including the last portion which I paid within the extended 10 days. Now, lordship kindly comes to.
Let us hear them directly.
Very well.
They will show me the clauses.
Number, may I say?
You have 3 grounds. One is they have said that within 21 days you did not pay. But you say that you have taken advantage of that clause of 14 days, further 14 days. You applied, you exercised the option, no reply by them. Rather, within 10 days you tendered, that was accepted by them. And subsequently, they refuse on the ground that was tendered by the lead partner. Although the security deposit itself was accepted by them, that was also paid by the lead partner.
And the actual rejection order does not say that it was not by the joint venture. The actual rejection order say that you did
not within 21.
That is the first ground.
Yes.
Subsequently, after 7 days, they say no, it was not by the joint venture. That is why we could not accept. So we are returning the balance FDs. So they have returned. And my lord, one more point, my lord, according to them, the last communication by which they returned our balance FD after forfeiting the security deposit, they say that as per our terms, it is to be only deposited by the joint venture. But the contractual clauses say it's not that. So far as if the payment is made by the ECL to the party, that has to be in the joint venture account. But it is not the contractual clause that the payment has to be also gone from the joint venture account.
Very well.
And there are judgments also, if your lordship requires.
That's not what point. Mahinder Single, no.
No, other point. From Kulija to Eurasian, my lord, and nothing.
What point are you wanting to say?
My lord, that there was no application of mine, my lord, is entire decision was perverse.
Cite the judgments, give the references.
And my lord, if your lordship kindly
within 5 minutes, give the references.
My lord, page
I'm
70.
just cutting short the times.
My lord, if your lordship kindly comes to page 73. Well, I have already, I have said your lordship what are my facts. Kindly comes to page 73.
Yes.
Kindly see, my lord, the security deposit.
Yes. What is your argument?
My lord, kindly see the Security deposit shall consist of two parts, performance security and retention money. The performance security should be 3% such and such. A bank whichever is within 21 days from the date of issue of LOA, letter of award. Now, my lord, kindly
show me the 14 days plus 14 days.
In the same page, kindly skip over 2 paragraphs. However, the company may approve submission of performance security beyond 20 days by another 14 days with proper justification on a case-to-case basis.
And you say there is no clause regarding that the joint venture has to put it as a joint venture.
It is other way around. In case they pay us, that has to be by the joint venture.
That is different. Show me the termination clause and the blacklisting clause.
Kindly comes to clause 9 at page 80.
This contract was regarding extraction of coal and removal of overburden.
My lord, as also for transportation.
Very well. Page
80.
80, right. And there, yes. Clause 9, right. Which clause has been resorted to by them? Which is the best clause in their favor?
They did not indicate. They say in terms of 4.2.
It can be the best clause in their favor. What's clause against you? Show me that, because that will be the ultimate argument. Instead of beating about the bush, let us come to that.
My lord, kindly comes to my lord.
Yes.
Clause 9.1 at page 81.
(8.1), yes.
9.1. 9.1 at page 80.
Right. What could be their argument? C. Very well. So this is all. And what about blacklisting? Anything provided here?
Well, that provide in the security deposit code 4.2, because in addition to this, they can provide, they can blacklist.
Let us come back to page 73.
Well, kindly comes to C 74.
74, yes.
First, there is a column, then all SMS fields, then original bank, then in case the successful bidder fails to submit the performance security and additional security within the stipulated time, then the award shall be cancelled with forfeiture of such and such.
That is termination.
Yes. Additionally, the company shall debar such defaulting contract from participating in future tenders. Now, my lord, kindly comes to the impugned documents, which also consists, my lord, one more parameters that your lordship may kindly also appreciate.
Yes.
My lord, kindly see their letter at page 216, 35.23.
Yes.
This is one of the challenge, 35.23. Cancellation of award such and such. Dear sir, as per the LOA in
the thing.
No, I am not. I am just looking at only pointing the part in any of the acceptable forms such and such to clause 7 of the JV. Kindly see, Melon. They say they are referring to clause 7 of JV, which according to them, Melon, that submitted, however, you have failed to fulfill the contractual obligation by failing to deposit the performance security in accordance to the terms and conditions. And within the stipulated time period, in view of the failure, in accordance with clause 4.3 of the general terms, the management ECL has decided to take the following action. Cancellation of award of hiring such and such.
Yes, forfeiture, cancellation and banning.
Now, kindly comes to the banning.
Yes.
Banning part. See, banning of business under clause 4.3, general terms and condition, under section 12, clause 2, 3, 3, 4, 5 of the guidelines of banning of business that itself referred. Now, what are the guidelines? My lord will find at page 218.
218.
We have enclosed the entire guideline and the relevant part.
Yes.
Kindly comes to section 12, the relevant part, and kindly, my lord, open the page 217, what they have referred, section 12, clause 2, 3, 3, 4, and 5. It starts with a mandate.
Show me the page.
At it starts with, my lord, guideline starts with 218, the relevant portion at 2 to 3.
Yes, 2 to 3, right.
2 to 3, section 12 at the top, guideline for banning. It is being Coal India.
Right.
Now they have referred to section 12, clause 2, subsection Roman 2, 3, 4, and 5.
Yes.
Now it comes under clause 1, observation of principle of natural justice. So they themselves, my lord, not only, my lord, followed with regard to banning, but so far as my application and submission of concern, there are documents, my lord, I need not to, my lord, travel.
No, no. One is observance of principle of natural justice. That they have not
Before
followed,
banning.
you are saying.
Yes, that is what I say.
That even without that, they have to follow.
But they have themselves referred and quoted. That is my intention, is to see, my lord, the palpability of, my lord, unreasonableness and arbitrary, my lord, this approach. And
How do 3, 4 these come in?
well, they say this. They say, I am not saying. They say,
Now, how does that come in? You did not get an opportunity to start that also.
no, because because there was not even a consideration that I paid the money, balance the money. There was no rejection of my application for extension.
Right.
And, my lord, kindly see at this.
No, repeated failure to meet contractual obligations. Had you started the work at all?
I was not, the work order was not issued. How could I start?
Let us see what this.
And, my lord, the last letter, because how they have written. Kindly comes to 225. This was of 35.
225, yes. By one of the partners.
One of the partner, and they have referred the joint venture agreement. It is nothing but a printed format of the ECL. We say, and this not is otherwise not prevent us. He says, Lordship, kindly see after the quotation, they have quoted as per the provision of bid submission, bid security. Now I will underline bid security. Performance security and other security shall be paid by the joint venture unless otherwise agreed. Now, for the time being, I take it this is against me. Now, it also contains bid security, which is the SD money. Had it been a case, then SD money was accepted by them. They have issued the LOA, L1. They have accepted my SD money. They have declared me the successful bidder, and LOA was issued. So, one way or the other round.
No, two wrongs do not make a right, they may say. The previous was a mistake. You committed two wrongs. On both occasions, the joint venture was to put in the money. But on the first occasion, they committed a mistake by taking it from one of your lead partners, from the lead partner.
Now, here,
they are not willing to commit that same mistake.
Unless otherwise agreed. Now, if your lordship kindly comes to the joint venture agreement.
That is the acceptance is the agreement.
No, I say that is unless otherwise agreed. Now, unless otherwise agreed, it is a joint venture. The joint venture company appointed one of the partner as a lead partner, and he was being authorized, and in his name, everything is to be done. If your lordship kindly,
payment is the joint venture's payment.
Yes, now and this is being also permitted. Kindly comes to the joint venture agreement. Just after that, we have also disclosed the joint venture agreement.
The page.
My lord, this is not being paginated. This is filed along with the Vakalatnama. The joint after this page 225 and 226. My lord, kindly comes to inner page 3 of the joint venture agreement.
Yes.
Well, kindly see clause 2, the lead partner. The lead partner is a Roma construction. Have your lordship found clause 2?
That is internal page 4.
Internal page 4.
Yes.
Shall be the lead partner of the joint venture and is in charge of performing the contract management. And Roma Construction shall be the attorney of the parties duly authorized to incur liability and receive instruction. So
they are not bound by your joint venture agreement.
This is their format. I have only followed their format. In NIT contains this exact format.
Very well.
If your lordship asks me to show this.
So NIT contains this format.
Exactly. And kindly comes to Millard. Their annexure. Yes, 119.
Page 119.
19. This is a format of joint venture agreement.
Right. So that lead, that thing is also, oh, yes. Very well.
And he is being authorized to incur liability and receive.
Let him argue. Yes, Mr.
Yes, my lord.
What defense?
First, my lord, the defense, my lord, where, my lord, the principle of natural justice was not followed, and my lord, we have not given him hearing, my lord. In that respect, my lord, I will say that my lord, he has not been properly instructed, my lord. Otherwise, he has not made this submission before your lordship.
Leave
My lord.
those aside, yes. What happened actually?
Kindly see, my lord. First show cause, reply. Second
Give a
show
copy
cause,
to him
reply.
also.
Yes, my lord.
Show causes were given to him.
So cause, my lord, specific so cause, my lord, saying that the reason is, my lord, mainly is that joint venture has to make payment, my lord. If your lordship is first.
Then I'll have to direct evidence.
17/4/2020.
We have suppressed this in your writ petition.
My lord.
So many show causes were given to you.
Thereafter, my lord, minutes of the meeting, my lord. Minutes of the meeting is also there, my lord.
there.
Petition number 2 is signing. Petition number 2 is signing. And what they have said, my lord, kindly see, my lord, this handwritten one, my lord. This one, my lord. They are admitted.
Mr. Basu, why shouldn't a writ petition be dismissed for suppression of this?
First so cause, my lord, thereafter, my lord, first so cause was given 17th of April 2023.
What is the admission, Mr. Arifin?
Yes, my lord. Kindly see, my lord.
I'm in the last page.
This handwritten, my lord.
Is this?
During the hearing, my lord, we have given him the notice.
Which paragraph? I mean, which portion? Show me in your copy. I'll find it.
Yes, my lord. First question, my lord, as and by joint venture, the company has deposited PSD money within 21 days from the date of issuance of LOA on 24/1/2023. But at that time, the account on JB not opened. But I said so from the agreement, my lord, that they have to open the joint agreement, my lord, due to non-availability of PAN card, GST, and trade license in the name of JV of single and deposited of a single partner has deposited 1 crore within 21 days from the issue of LOA. Now, the second question, why PST amount is not deposited in the name of joint venture?
How soon can you file your opposition?
3 weeks time, my lord.
Why 3 weeks? You have the documents.
2 weeks.
File it in 2 weeks.
My lord, may I say this? My lord,
I'll direct affidavits, Mr.
My lord, I have just taken instruction. My lord, so far as this letter is concerned, my lord, we have disclosed. My lord, kindly comes to.
You did not point out to me.
No. This was with regard to they say.
Highly considered para 17. They say, my lord.
They say after submission of the additional sum, which is within the extended period.
This is a show cause notice for cancellation of the LOA with forfeiture and banning.
No, this document.
That is
this document I have also
Issue.
seen for the first time.
The
kindly comes to
the petitioner contends that there are several violations of natural justice as well as the terms of the contract between the parties. Insofar as the respondents have terminated the contract of the petitioner and forfeited the amount of security deposit which was put in by the petitioner, along with banning the petitioner for 1 year, dehors the provisions of the contract. So it is submitted that although there was a specific provision in the contract to the effect that the petitioner would get 14 additional days and 14 additional days after the expiry of the stipulated 21 days, for payment of performance security deposit within bracket PSD bracket closed, along with the option to be exercised by the petitioner regarding whether the security deposit is to be adjusted to the PSD, such clause was not followed by the respondents. Full stop. The petitioner deposited the PSD within 10 days after the expiry of 21 days, which was accepted by the respondents, but subsequently returned on the frivolous ground that the lead partner of the joint venture had deposited such amount. Full stop. However, in the same breath, it is argued that the respondents' authorities themselves had accepted the security deposit and declared the petitioners to be the lowest bidder, which deposit itself was tendered also by the lead partner of the joint venture. Full stop. Next para. That apart, prior to blacklisting, it is submitted that no hearing was given to the petitioner. Full stop. Next para. Learned counsel for the petitioner, comma, while controverting the petitioner, learned counsel for the respondents, sorry, while controverting the petitioner, comma, hands over a copy of purported show cause notices, comma, which are several in number, comma, issued to the petitioner
And they're given reply.
on the question of why the LOA should not be cancelled with forfeiture of EMD stroke security deposit, comma, along with banning of business. Full stop, it is submitted that thereafter, comma, a hearing was given and the minutes of such personal hearing, comma, inter alia signed by the petitioner, comma, are also a part of the said bunch of documents. Full stop. Hence, comma, the issues cannot be reopened at this juncture. Full stop. Moreover, comma, the allegation as to not giving any hearing to the petitioner on the debarment is also frivolous. Full stop. Next para. It transpires from the said copies handed over by the respondent that certain vital documents have been suppressed by the writ petitioner. Full stop. However, comma, in order to adjudicate the dispute raised comprehensively, comma, the respondents are directed to file their affidavit within bracket S in opposition, comma, annexing all relevant documents. Full stop. Such affidavits in opposition shall be filed within a fortnight from date. Full stop. Reply, if any, shall be filed within a week thereafter. Stop. The matter shall be listed for hearing on July 17, 2023. Mr. Basu, you should take care in future.
The petition ought to have been dismissed with cause, as your lordship said. This was not within my knowledge. For the first time, I have come to
That
know.
I know, Mr.
I
Basu.
said,
Obviously, it was not either within your knowledge or your.
Otherwise, on other, I could not have even tried to swear to
Basu,
your lordship.
because of the bona fides, I did not dismiss it in limine.
This was the first time I've seen. May I should not have
It says
said
you have
anything more, but may I not press it? I should not have.
Let them come up with this.
Deeply obliged.
Give in your reply, give some reason.
Absolutely, I should not
And
have.
hope that the bench determination is changed in the meantime.
Deeply obliged.
Call on the next matter.
25.
But if it's possible, lordship, kindly permit them to withdraw, not press it.
You can do that at any time, but for your defense, please just take a written instruction on that. You can do it, I'll give you liberty
Then
to file
kindly
appeals.
keep it day after tomorrow as
I
per your-
passed my order. After that also, at any time, you can come up and say that I want to not press the
Very well.
or withdraw
I'm
the
extremely
matter.
sorry to is
No,
not
no,
in my
sir,
knowledge.
Not at all. Yes, call on the next matter.
I said he has not been.
Malad,
properly instructed.
this would be an example how a good case may be bad. I could have been taken defense with regard to those
How good,
papers.
my lord, I have not opened my case also, my lord. I have not shown the clauses, my lord.
It has demolished entire 15 minutes and your lordship judicial house.
No, not my time. Yes. Your time, actually. The other litigants' time.
My lord.
Yes, next matter.
25.
25. None appears for the parties, adjourned for the week. Next.
26. Upgraded matter.
Mr. Banerjee, your matter? Yes. what
Lord,
is it?
a short question.
Mr. Banerjee, has the
Lord-
service been effected properly?
Yes,
Please check up.
Lord.
Mr. Pine, please check up.
Yes.
Everybody.
All have been served.
Everybody has been served.
Very well.
After the mentioning, even my lord,
Notice was given.
Lord, the notice was given and.
Anyway, Mr. Banerjee,
Lord,
yes. What is the matter?
Lord, a short question.
Your short or my short?
My short question.
But that will be long.
Before your lordship, because I do not want to take your lordship.
No, Mr. Banerjee, please argue. Yes.
Lord, only question is, my lord, that under the Society Registration Act,
Yes.
Lord, under section 17 of the Society Registration Act,
Right.
the annual return is to be filed before the joint registrar. Joint registrar will forward it to the registrar for only to keep it in terms of that. But there is no provision for refusal. Lordship, kindly see, my lord. My prayer is prayer 2. They refused it. Now, my lord, why they refused it? Now, your lordship, there is a penal clause, subsection 4. Therefore, it is mandatory. There is a penal clause, 17, subsection 4. $250 fine.
Thank
you. Now, my lord, why they are refusing? Because, my lord, the erstwhile, lord,
They're refusing to do what? Forward.
why they are refusing?
They're refusing to forward.
No, they are refusing to accept it.
Why?
That is why they are refusing. That is why I'm telling your lordship.
No, you have done it within 30 days.
Within 30 days, 30, no. 30
Within 30 days
from
after holding any annual general meeting, there shall be filed with the registry.
Yes, within 30 days.
So have you done it within 30 days?
Within 30 days, we went there. We are not allowed to because we deposited the amount. We were not allowed to deposit the amount. Even the form was not supplied to us. Lord, that is why this is the REIT application.
Then notionally, Mr. Banerjee, they can also take a point that you did not tender within time.
No,
may
they
take
did not take. Lord, they have said
They have no
no
opportunity to take.
because their case is, my Lord, your lordship, I have annexed that document. Your lordship, kindly come to this page, my Lord.
Yes.
Lord, page, my Lord, 39.
39, yes.
39.
I'm there, yes.
Lord, legible copy, my Lord, I have given at
This is
page
legible.
48.
This is legible to me.
48, my Lord.
Yes, yes.
Lord, paragraph 5, my Lord.
5, yes.
On 2/11/2018, Amalendu Bika Jana, Secretary of the Society, applied before Joint Register of the Office of Farms, Society Non-Trading Corporations, Purvomed Report, for filing annual return of the Society for 2017-18 FY and informed that Amal Baran Bhumik fraudulently claims to be the Secretary of the Society and submitted annual filing return He has been removed from the post of the Secretary, Contai so-and-so by resolution number so-and-so. Lord, then, Lord, a new committee member has been constituted. Now, Lord, that resolution, my Lord, has been challenged by filing a civil suit. Now, civil suit, my Lord, resolution, they wanted to not to give effect to that resolution. Civil court did not grant. Civil court granting order of a status quo as on today be maintained.
If there is status quo, then this person does not have as the secretary the locus standi to file the annual.
That's right.
You do.
No, I have, because the status quo, my Lord, on the after the resolution has been passed, then challenged.
No, you are the new committee.
New committee.
New secretary.
New secretary.
No, on 2nd of November 2018, Amalendu Vikas Jana, secretary of the society, applied. You are Amalendu.
I am Amalendu because I am Amalendu.
You are Amalendu.
Yes.
Achha.
And he was removed.
So Amalendu
Not
tendered.
Amalendu. The non-trading corporation submitted.
Amio Baron Bhumik was removed.
Return.
Are you Amio Baron?
Amio Baron Bhumik
was removed.
Fraudulently claims to be the secretary of the Amio Baron Bhumik, my Lord.
He has been removed.
He has been removed. Amio Baron Bhumik has been removed.
Yes.
Lord, plaint, my Lord, page 41. Amio Baron Bhumik, my Lord.
You have not given a name who is the secretary, represented by the secretary.
Previously, my Lord, Amio Baron Bhumik was the secretary.
Who has affirmed this?
He was removed.
Yes, Amalendu, you are Amalendu.
Yes.
That is what I asked you. You are
Yes,
Amalendu
yes.
Vikas Jana. You are the applicant on whose application Amio Baron was removed.
Therefore, a status quo that has been granted, your lordship, kindly look to the interim order.
Mr. Banerjee, is there any scope of any identity order in this matter?
Yes, my Lord, I may be permitted to submit it, subject to the result of the.
Oh, they are not permitting you to submit at all?
Yes. Lordship, kindly look to clause 2 of
very
my
well,
petition.
Actor. Learned. I'll permit you.
Onwards.
Yes.
Right.
I'll keep the writ petition pending. I'll permit you subject to the result of this.
Subject to the result.
Has to be, yes. The learned senior advocate appearing for the petitioner contends that by virtue of an application filed by Amalendu Vikas Jana, the present secretary of the petitioner number 1 society, by virtue of an application bollam ki bollam just ekটু on November 2 2018 it was informed that the erstwhile secretary Amio Baron Bhumik fraudulently claims to be the secretary of the society and submitted annual filing of return for 2017-18. Full stop. It was further informed that the said Amio Baron Bhumik has been removed from the post of secretary. Full stop. Accordingly, Amalendu Vikas Jana, the new secretary, and the person who has affirmed the instant writ petition, comma, sought to file the returns of the society with the joint registrar. Full stop. It is contended that as per section 17 of the West Bengal Societies Registration Act 1961, comma, the returns are to be filed within 30 days after the holding of annual general meeting. Full stop. Such filing, comma, thereafter, comma, has to be forwarded to the registrar. Full stop. Next para. In the present case, comma, pursuant to clause section 17 within bracket 1 within bracket small b of the act, comma, an annual report by the governing body on the working of the society for the previous year was duly filed. Full stop. However, comma, the respondent authorities have not accepted the same on the ground that the joint registrar sought from the registrar clarification as to whether the joint registrar would approve the annual filing of return of the society, and, comma, if so, comma, then claim of which party stroke group would be considered for such approval. Full stop. Next para. The learned senior counsel further contends that subsequent to the resolution in question, comma, a civil suit has been filed, and thereafter the civil court has passed an order of status quo as on the date of passing of such order. Full stop. By virtue of the status quo, comma, it is submitted, comma, the new incumbents are now functioning as the secretary of the society. Full stop. Hence, comma, there is no impediment on the part of the authorities to accept the filing of the return by the present secretary, that is the person who is acting at present as the secretary, that is Amolendu Bikas Jana. Full stop. Next para. A perusal of the provisions of section 17 of the said act reveals that the mandate of law is that the annual report of the governing body has to be filed within 30 days from the annual general meeting. Full stop. In the present case, comma, although apparently tendered within such time, comma, the same was not accepted by the respondent authorities, comma, thereby seeking to avoid contravention of the provisions of subsection 4 of section 17 of the act. Full stop. That apart, comma, unless such filing is accepted, comma, the petitioner number 1 society shall also be liable of contravention of the law. Full stop. Hence, comma, the respondent authorities are directed to accept the filing of the annual report,
Annual return, my lord.
annual return and annual report by the present petitioner, that is the society, comma, represented by its current secretary, Amolendu Bikas Jana. Full stop. Such acceptance shall be given effect to, comma, of course, comma, on an ad hoc basis, comma, subject to the outcome of the present writ petition. Full stop. In the meantime, comma, subject to the further orders which may be passed in connection with the civil suit and or this writ petition, comma, the present secretary, that is Amolendu Bikas Jana, shall be tentatively permitted to act as the secretary vis-a-vis the respondent authorities and to comply with all statutory requirements, comma, insofar as the present respondents are concerned. Full stop. Next para. The respondents shall file their affidavits in opposition within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. The matter shall next be returnable on in the monthly list of August 2023. Full stop. Affidavit of service filed today be kept on record. Thank you.
Lord, I am deeply.
But তিনটে অরিজিনাল সাইড থেকে, তাহলে অরিজিনাল
But without Lord annoying my Lord,
Yes.
without annoying my Lord, at the risk of getting admonished,
Yes,
Lord,
what is it?
item number 31, your Lordship had upgraded it, my Lord, on the urgency that 29th is the date fixed for auction.
I'll take it about 3:30.
Very good.
My lord,
I'm grateful.
my lord, in original said matter, my lord, lordship, my lord, delivered a judgment yesterday.
On Friday, Mr.
Friday, I do not have problem, but tomorrow, my Lord, is the date for auction. That's the only difficulty. That's
Nothing
why, my
doing.
Lord,
I could
else
not
I
reach
don't
it.
have.
You have a resolution at 3:30 today.
But I leave it to your Lordship, my Lord, that's the only difficulty.
But
else I
3 is the
wouldn't-
last, I mean, before
wouldn't have
I have to
bothered
take
your
up original side matters now.
But I
Nothing doing.
My lord, in original said matter, my lord, yesterday lordship delivered a judgment in item number 1, my lord, Hindustan Petroleum Corporation, MMC, my lord, in paragraph 14, my lord, lordship, my
You
lord.
mentioned, give a slip to be mentioned tomorrow. Correction.
Yeah,
To be mentioned tomorrow. এই স্লিপটা একটু নিয়ে নেবেন, ওই কালকে পরশুদিন থাকবে টু বি মেনশনড কারেকশন ওয়ানটা কল।
Item number 1 and 2.
Accordingly, WPO 2291 of 2022 is dismissed on contest without any orders to cost. It is made clear that the petitioners in WPO 2291 of 2022 will be at liberty to initiate appropriate procedure. I have held that Etibar will have to, the lien put on Etibar's account is valid. And regarding Traco will be absolved of the liabilities. Their lien will be reversed. And ICICI will not be responsible. It will be between the Central Bank of India and the Etibar for the time being. I'm reading out my order. Accordingly, 2291 is dismissed on contest without any orders to cost. It is made clear, however, that the petitioners in WPO 2291 of 2022 will be at liberty to initiate appropriate proceedings against Messrs. Traco, petitioner number 1 in WPA 2970, if in the perception of Etibar, Mr. Straco is liable to pay any amount to them, because you have taken a point that you owe something to him. Nothing in this order shall unnecessarily influence the forum court deciding such dispute between Etibar and Traco. WPO 2970 of 2022 is allowed on contest, thereby directing the respondent number 2 therein, that is ICICI Bank Limited, to immediately reverse and negate the impugned action taken by it against petitioners by negating and neutralizing the lien marked regarding the account of the petitioners held with the ICICI Bank, and crediting back any amount which might have been debited by the ICICI in respect of accounts held by Traco Enterprises with it on the alleged cause of action which has been impugned in WPO number 2970. No address to cause urgency report. Thank you. Traco will reverse what the ICICI will reverse whatever against Traco. Traco will get back the money. ICICI not to pay anything to Central Bank of India for the time being. Central Bank will take whatever steps they have taken. That will be just that remains. So Etibar suffers. Yes. No, what?
To be mentioned, item number 3.
My lord, I am for the petition.
If why to be mentioned?
My lord, for correction, my lord.
Yeah, what is it?
Zillion Infrastructure Private Limited. It would be, my lord, Zillion Infra Projects Private Limited, my lord.
Infra projects. In the cause title?
In the cause title, my lord.
Only that?
Only there, my lord.
Learned counsel for the petitioner rightly points out that in the order dated May 10, 2023, comma, in the cause title, comma, the expression infra projects, double inverted infra projects, dekhe likho it, has been erroneously printed as infrastructure after the expression within double inverted zillion. Full stop. Let such expression be deemed to stand corrected accordingly. Full stop. This order be deemed to be a part of the order dated May 10, 2023. Full stop.
I'm grateful, Lord.
আচ্ছা একটুখানি বলে দিতে হবে যে দিস অর্ডার বি ডিম টু বি আ পার্ট, এটা কিন্তু ওটা আগের অর্ডারে ওরা কারেকশন করে দেবেন। হ্যাঁ, এটা দিস উইল বি ডিম টু বি আ পার্ট। নেক্সট। হ্যাঁ, পার্ট। হ্যাঁ, ডিমড বললে তা হয় না, ওটা ডিগ্রি কারেকশন হয়। আপনি যেটা বলছেন, আমার কাছে নিয়ে গেছিল ওটা। ওটা ডিগ্রি কারেকশনে হয় ডিমড করলে সেটা হবে না, দিস উইল বি
New motion, section 11, item number 4.
Your lordship is better. I take the appearance of the respondent. I believe the copy
You
has been
agree?
served. No, I believe the copy has been served in the morning only, and I've been served only a short
now
while
we are
back.
in the afternoon, so let us see.
Let me have a look at it, Your Lordship. Let me take instructions.
What is your
immediately.
instruction?
I don't have the instructions.
The
This was
instruction is-
supplied only a
Who gave you instruction to appear in the matter?
I only have the instructions because this has been served on the awards
Actually,
office
I
only in
have
the morning.
served on the authority.
I have
Now,
not
I
served it.
thought, my lord, I should serve on the advocate on record for the state of West Bengal also.
Yes, so
You
that
have served on the authority proper service.
My lord, I find, my lord, it is not been, my lord, it's
So
still
then I'll take
only-
it up on Friday.
Lordship, kindly takes it next. Tomorrow is a holiday, Lordship. Kindly takes it on Monday.
Friday.
Friday.
Friday, understood. Tomorrow we need.
Tomorrow is not Friday.
Tomorrow is not Friday. Need to take the instructions.
No.
That was
Friday.
Their response is on record.
An adjournment is sought by learned counsel having instruction to appear for the respondent. So accordingly, let the matter stand adjourned till 30th, June 30th. Affidavit of service filed today be kept on.
Obliged.
Court applications, item number 5.
5, yes.
My lord, in this matter, I want to proceed expert review. There is urgency. There is an urgency. My prayer is there, and High Court rules, original side rule, there is a permit for this. I made an attempt for.
This is governed by Rule 26.
Yes, my lord.
Yes.
The point is this.
Those are the REIT rules, probably.
Yes. This is against the termination of contract, but the bid opening date is the Saturday. That is the urgency. But the fresh tender on the same very work.
When did you file it?
I filed it tomorrow, yesterday.
Yesterday, why couldn't you give a copy? You sent a copy?
I have already sent.
Acha, very well. What
I
is
have
that?
already sent the copy and they have already received also.
What is the matter? Let us see.
Well, kindly come to page number 13. I am giving the just brief. Page number 13 is the nature of work.
Yes.
Construction. This is a acceptance letter. Construction of caustic washing bay, including washing cum cleaning facility with caustic tank and EOT crane at Kakinada. This is the nature of work that has to be undertaken by my client, but the petitioner here. That is the work order 10 December 2018.
Very caustic observations. The entire thing is caustic. Anyway, what is the irregularity, Mr. Bhatt?
Irregularity, my lord, I am coming, my lord. Then, my lord, kindly come to 21. This is the second writ petition. In the previous writ petition, your lordship passed an order on 22nd because the G, against the G, there is a demanding from me. And against this, the investigation is going on. Your lordship's call for the report on the 7th July is the date for placing the report. It is the second contract. That was the first contract. It is a second contract between the same very parties. It is actually a product of a revenge. Because I made a complaint against him, first contract is supposed to be cancelled and this is already cancelled.
Apart from the revenge, any other?
Yes. I am coming to the, this is the allegation is page number 21 that on previous occasion I have noted, that is they have demanded money, that is page number 21. Then come to.
You are challenging the tender process itself.
The next, yes, floating the next cancellation as well as the fresh tender, both.
So
What is the illegality? I am coming. Just give 2 minutes.
So in the technical bid, your bid was not accepted.
No, I have already done 52% work.
Oh, the work has been done.
Work has been done.
Your contract has been terminated.
Yes.
What is the termination letter?
Termination letter, my lord, that is. Page number 35. There is a type copy.
Is 35?
35.
Yes, 35.
This is a termination letter, 18th February.
Due diligence, default, etc. Very well.
Just prior to that page, my lord.
Yes.
There is a gate pass, 33 and 34. Though the 31st of May 2022, the extension period is over. Thereafter, I was doing the work unofficially, and they are issuing the gate pass time to time. The last gate pass is page number 33, that is 15th February 2023.
Unofficially doing means?
But as such, there is no official order to carry out because as per the extension order that is expired on 31st May 2022. No further extension has been given officially.
So you could not do the order after
But they are issuing gate pass for doing the work, and the work
pass is not admission on that score. Gate pass is the issuance of gate pass by the whoever is there is not a extension of the contract.
No, that's true. That's true. But they are doing the work even after the expiry of the period, extension period.
So why have you been terminated? Because you could not complete the work.
That is their plea. But actual meaning is
scope of any interference at this stage.
no. You have your lordship has. I'll satisfy. I'll satisfy.
I'll recall that order also.
I'll satisfy.
Because of gate passes.
Will kindly come. The comparison between the first work order and the second NIT. That is page number 30. The initial the work value was the 2 crore 37 lakhs.
Yes.
And 52% work has been completed. The remaining value of the work would be 1 lakh 13,000. 1 crore 13 lakhs. 1 crore 30 lakhs the remaining value. But the next contract is a value is 2 crore 44 lakhs. That is page number 36. That means the value of the original contract is exceeded. This is mathematical issue. If I have completed 1 crore job, then the remaining value would be the 1 crore.
At the time when the work was given to you, at that point of time, they valued the work at a particular rate.
0.37 crore.
Yes.
That is
now the
escalation
rates have
cost.
increased. Yes.
Escalation
Now the
cost
rates have increased. Therefore, a part of that costs more than what that part cost earlier.
I am ready to complete the remaining amount.
Your readiness won't do. They have terminated your contract because you could not complete within time.
That is their plea, my lord. That is their plea. I could not complete the work, but now I am ready.
Position, your gate passes cannot improve.
No, I am not. I am citing one thing, but apart from this, point is this: the value is this 2.44 crore.
Yes.
So I am ready to complete the work on 1.13 crore, the remaining amount.
That does not give you a right.
They are not giving. They are not allowing. What actually point is this? They are not allowing to enter into the premises to complete the work.
The time is over. That's why.
That is not first initial attempt of this. But I am still continuing to complete the work that they are not cooperating because of the reason that I have made a complaint against them. I have made a complaint against them. That is the issue.
Mr. Dattu, what is the ground of termination? Because you have not completed the work within time.
Yes.
That is the
ground. That is the ground.
If you have not completed the work within time, then as per the contract, you are not to be terminated. Automatically, you are terminated.
But that's true. That's true.
If you are terminated, then where is the scope of challenging that? And where is the scope of revenge? They have not exercised an option of extending the time, maybe. But that's their discretion.
Actually, what actually happened there, they are officially granting the time, extension of time. But in all respect, they are not cooperating to complete the work.
Officially, they are not granting time. Only unofficially, they are giving passes.
Yes. Kindly consider this thing. I will rely on judgment of the Supreme Court on the same some footings when the financial burden.
What? Get passes?
No, not get pass. When the financial burden of what actually happened here, I am ready to complete the work 1.13 crore. They are on the same very work. They are quoting for 2.44 crore.
So
double of this.
I'll have to refuse your identity prayer. I'll direct
it. Otherwise, I'll be difficult. If they bid, kindly see the bid opening documents.
The usual toothless order, Mr. Dattu, which does not have any meaning, I'll pass. This will abide by the result.
Kindly catch page number 41 once, then there are your lordship what decided.
Page 41, definitely, yes.
Page 41 is the bid opening. They are repeatedly corrigendum issuing. 8th May 2023 is the publishing date. Then they have again corrigendum type it is. 8th May, then 12th June is there, then 1st July is their bid opening day. I am praying for only short for a period of time, on 15 days, your lordship stay, granting stay. Let them appear and they, because the work is already stalled for a 3-4 months. Only 15 days, that will not happen anything.
There are two admitted positions. One admitted position is that you could not finish the work within time.
Yes.
Thereafter, extension was probably once or twice granted.
Twice granted.
Yes. After that, even then you could not complete the work for some reason. You may have your reasons, but for that they have terminated the contract and they have said they have floated a new tender for the remaining work. That new tender demarcates the job at a rate which is more exorbitant. I mean,
original contract value
than the original contract.
Whereas I have already completed 52% contract.
That does not give you a right to stall the.
Yes, that is the judgment.
I have only one copy. I think the last pages is the relevant.
You can read out the relevant portion. You can
Yes,
read out the
yes.
relevant paragraph and then
So very
just the relevant portion, Mr.
yes.
Give me the citation and the paragraph number.
Citation in 2020-22 6 SSC 123. This is
2022.
2020-22.
2022.
2022. 2022 6 SCC 127 NG Projects Limited.
Any particular paragraph, Mr. Datta?
Yes, yes, 24, 25, and 27. That was the same proposition there. He has also completed a certain.
Read out the relevant portion.
Yes, the state has paid over a sum of rupees 3.98 crore to the appellant till date. Though the stand of the appellant is that it had submitted bills of work of rupees 8.50 crore. The termination of contract would be cause additional financial burden on the state and also deprive the amenity of the road for a longer period. The learned counsel for the appellant has stated that they shall not claim escalation of cost for the period even the writ petition before the High Court was pending and there is a stay granted. In view of thereof, we find that the action of the respondent in setting aside the letter of acceptance granted to the appellant suffers from manifest illegality and cannot be sustained. Consequently, the appeal is disposed of with the direction to the respondent state to allow the appellant to resume the complete the work by excluding the period spent in the stay of the execution of the contract. Next, paragraph 27, we also find the multiple layer of exercise of the jurisdiction also delay the final adjudication challenge in the grant of tender. Therefore,
Mr. Datta, let me see that judgment now. Yes.
Look, that is my point. If I am ready to pay, complete the work 1.13 crore and somebody will come and they will claim for 2.44 crore, the double of the amount, that is obviously it is a public burden of the public exchequer.
No, it was the other way around. I'll record this judgment. I'll give my reasons, Mr. Datta. I'll have to refuse it.
Your Lordship.
Thank you. Learned counsel contends that the petitioner has already completed a substantial portion of the work, that is about 52%
Yes, yes.
of the same. First up, it is argued that although the stipulated time as per the contract was expired, comma, 2 subsequent extensions were given to the petitioner. First up, the petitioner is also ready to undertake that the petitioner shall expeditiously conclude the work, comma, if given another extension. First up, next para. It is further argued that although no formal extension was given for the completion of the work, comma, gate passes were being issued by the respondent authorities for the men of the petitioner to continue the work, comma, which tantamounts to acceding to the petition ACCEDING, acceding to the petitioner continuing with such work, full stop, as such, comma, if at the present juncture the impugned termination of contract of the petitioner is not interfered with, comma, it will involve huge unnecessary expenditure to the state exchequer. Full stop, it is submitted that a new tender floated for completion of the remaining work, comma, left unfinished by the petitioner, comma, indicates that the tender value is much more than the cumulative value of the petitioner's work. Full stop, as such, comma, since a fresh tender would only entail unnecessary expenses on the part of the respondent authorities, comma, it would be commercially prudent to continue with the tender process by giving the petitioner another opportunity to finish the work started by the petitioner. Full stop, that would save much public money, comma, it is argued. Full stop, next para, learned counsel places reliance on a judgment of the Supreme Court rendered in NG Projects Limited versus Vinod Kumar Jain and others, reported at 2022 6 SCC 127. Full stop, by placing particular reliance on paragraphs 24 and 25 as well as 27 of the said judgment, comma, it is contended that the Supreme Court went on to observe that the state had paid over a sum of rupees 3,98, 52, 396 to the appellant till that date, comma, though the stand of the appellant was that it had submitted bills of work of rupees 8.5 crores. Full stop, the termination of contract, comma, it was held, comma, would cause additional financial burden on the state and also deprive the amenity of road for a longer period. Full stop. In view thereof, comma, the Supreme Court went on to observe, comma, it found that the action of the respondent in setting aside the letter of acceptance granted to the appellant suffered from manifest illegality and could not be sustained. Full stop. Next para. It was also observed that multiple layers of exercise of jurisdiction also delay the final adjudication challenging the grant of tender. Full stop. Therefore, comma, it would be open to the High Courts to entrust the petitions to a division bench of the High Court, which would avoid hearing by one of the forums. Full stop. Next para. Such consideration of the Supreme Court, comma, in directing the High Courts in the said case to assign the matter to the division bench, comma, unfortunately is not available to this court, comma, particularly to a learned single judge. Full stop. Next para. Insofar as the rest of the observations are concerned, comma, the judgment has to be read in its entire perspective. Full stop. A perusal of the narration of events which led to the said adjudication indicates that the impugned tender therein had culminated in the issuance of work order in favor of a particular party, comma, which had already started its work and completed approximately worth rupees 8.4 crores of work. Full stop. Next para. Plants and machinery had been mobilized pursuant to the work order. Full stop. Next para. At that juncture, comma, there was an interference by the High Court to the tender process, comma, thereby entailing the floating of an entirely new tender for the same work. Full stop. In such context, the Supreme Court rendered the findings as indicated above. Full stop. Next para. However, the Supreme Court also considered several other judgments and deduced certain principles to the extent that the modern trend points to judicial restraint in administrative action. Full stop. It was further held by the Supreme Court that the court does not sit as a court of appeal, but merely reviews the manner in which the decision was made. Full stop. Thirdly, it was observed that the court does not have the expertise to correct the administrative decision. Full stop. If a review of the administrative decision is permitted, it would be substituting its own decision, without the necessary expertise, which itself may be fallible, F-A-L-L-I-B-L-E, fallible, full stop. Next para. In such context, it was further observed that the terms of invitation to tender cannot be open to judicial scrutiny because the invitation to tender is in the realm, REALM, of contract. Full stop. Normally speaking, the decision to accept the tender or award the contract is reached by process of negotiations through several tiers, TIERS. Full stop. More often than not, such decisions are made qualitatively by experts. Full stop. Next para. As such, the Supreme Court went on to deprecate interference by courts in issuance of work orders in terms of tenders. Full stop. Next para. However, in the present case, the factual scenario is just the converse. Full stop. Here, the petitioner was actually given a work order, which the petitioner admittedly could not complete in due time. Full stop. Subsequently, 2 extensions were given to the petitioner to conclude the work. Full stop. However, despite the same the petitioner failed to complete the work, for whatever reasons. Full stop. Next para. As such, keeping in view the urgency of the public project, the remaining work has been sought to be awarded to a third party, by way of floating a fresh tender. Full stop. The mere fact that the valuation of the work as per the new tender does not tally with that of the previous tender does not ipso facto vitiate the floating of the new tender. Full stop. Times change, along with cost of living, and as such, the variation in price on a temporal basis, cannot be sufficient to vitiate the veracity of a tender process. Full stop. Next para. Moreover, there is nothing in the present case, at least on a prima facie footing, to indicate that the tender issuing authority have committed such patent illegality, arbitrariness, malafide act, or irregularity, justifying interference by the writ court and/or passing of an ad interim order interdicting the public work by restraining the fresh tender process. Full stop. Next para. Accordingly, the interim order prayed for by the petitioner is refused at this stage. Full stop. However, in view of the petitioner having made out an arguable case, since so much space had to be devoted to counter the petitioner's arguments, the respondents shall file their affidavits within 3 weeks from date. Full stop. The petitioner shall file reply, if any, thereto within a week thereafter. Full stop. The matter shall be listed in the monthly list of August 2023 for final hearing.
One mistake, I think, in the dictation.
Yes, Mr. Datto.
That is your lordship's held In our court, we cannot assign the matter to the division bench. That is not correct, because I think in the monthly list, this is very clearly mentioned. If any dispute in relating to a public interest matter, the single bench can assign the matter to the division bench.
That is
In
the
our,
point.
in our High Court rules is permitted.
A single bench.
Has the power, has the power.
If
Single
there
bench
is
has the
a,
power.
if there is
Single if there is public interest involved in the
what
matter.
is a public interest here?
Public interest means
It's a contractual matter.
But,
I should not have entertained it, but because you argued
That-
so well
that-
and on the logic that I had to take so much time to counter your argument for refusing your prayer, you deserve a final hearing in the writ petition. That's why I've directed affidavits. Otherwise, I would have refused it.
Okay, next.
Yes,
matter,
Mr. Mitra, next matter. Your
give
reply will comprise of how much time?
5 minutes, my lord, if your lordship, but your lordship will have to give me the.
No,
you are beyond time.
No, if you assure me that you will complete in 5 minutes, I can take up the
Yes,
matter.
yes,
Mr. Srivastav is there.
Yes, I'll finish in 5.
So other matters are released in any event. Yes.
My lord,
Call korota niye nahi ho raha.
I haven't replied, so my lord, I'm not having
No, no, Mr.
regard
I know that. Yes.
to the time constraint also, my lord. Kindly see, a case has been made out that I have suppressed something very serious. That's what I gather. So I am not entitled. One who comes to equity, one of these maxims of equity must come in clean hands. I have come in dirty hands, so I should go back to the dirt and filth and not receive any honors from your lordship. Now, my lord, non-disclosure of a document does not amount to a suppression. Non-disclosure must be actionable. That is, if I had shown that document, the judge would not have passed the order. There may be so many documents. I might consider it's totally irrelevant. That doesn't make it suppression. Now, kindly see, my lord, even if that is it, he had made the same argument before the division bench. And, my lord, the division bench rejected it, upheld Justice Mantha's order. And then when he realized, my lord, that the appeal was going to be rejected, he said, kindly extend the time given by Justice Mantha to make the payment. So, my lord, he derived a benefit. He got an extension of time to make, because I filed a contempt. He didn't want the SBI officers to be held up for contempt. So he said, my lord, kindly extend the time, I'll make the payment. So he's acquiescing to Justice Mantha's order. And the division bench says very well, since you come up before the division bench and time is taken, so we extend the time to make the payment. Now he has made the payment. Who has made the payment? SBI has made the payment, not Phoenix. So, my lord, what is the, kindly have a look at page 25 of my affidavit. I'll just read it out. In compliance with order so-and-so division bench comprising of the Honorable Chief Justice and Honorable Justice Bhattacharya and also order date 17.5 passed by the Honorable Justice Rashid Mantha underlined herewith forwarding the fixed deposit receipt bearing account number so-and-so dated so-and-so issued by PNB branch calculated for a sum of 87 lakhs 11,844 which was deposited by the State Bank of India with his registry and so-and-so. So this, so my lord, they've accepted the order, they've complied with the order. And now they are saying, no, no, no. And division bench, my lord, they have taken that point. Can you see the division bench? And my lord, who is giving the sale certificate? A party who has been adjudicated as not to be a proper and necessary party. And my rights, my lord, your lordship has seen. This is accrue much before the assignment. In 18, and Mr. Joy Shah, my lord, has, my lord, with all due respect, my lord, he should have given some dates. My lord, I have made my earnest deposit payment on 25th of July 18. Then the first tranche of 25% paid on 3rd of August 2018. And the balance, my lord, paid on 14th August. And 6th, thereafter, they let me know that an order had been passed by the DRT staying the sale and any further steps. So if they had told me, my lord, that the sale has been stayed and we cannot take any further steps, I wouldn't have paid this 41,25,000.
My lord, my learned friend is again arguing in factual aspect.
No, I'm just pointing out the list of dates.
She's supposed
No, what
to
is
reply to our.
No, I'm giving reply to what he has said. I'm replying to the list of dates, which is I'm replying to his list of dates, which does not create the date. After 14/8/2018, my lord, I wrote a letter on 6th of September 18, which is a P6, page 29, asking for possession. So, my lord, I asked for possession as early as on September 18, after paying the balance consideration on 14th. And then they said on 14th September, they tell me an August order has been passed on 7th.
Mr. Mitra, I have
August.
already got your list of dates, so it's.
My lord, what is the separation here, my lord? I don't
So
understand.
can you just, because Mr. Shaha has used a
Sir, can you kindly see the
short written notes of arguments, can you just put in a short written note for arguments on Friday?
my lord, what will I say? My lord, kindly see, I'll just see the division bench order, my lord, it's very clear.
Put that in your
Look, it just says this. I'll just submission of the learned counsel of the appellant, that is Mr. Joy Shah, is that earlier in page 21 of my affidavit of the affidavit in opposition,
yes,
their document, affidavit in opposition filed by Shangamitra Gangopadhyay on 21st of December 2022. Not you got it? Page 21, last para, submission by the learned counsel of the appellant is that earlier in writ petition so and so, petitioner had taken the stand that either money deposit be refunded or the sale certificate. Not a single letter, my lord, I have stated that you either give me the money or the property. No Hobson's choice here. I only wanted the money after I came to know that the sale has been stayed by the DRT. And the question, my lord, that I did not participate in the DRT. Who am I? Look, they are settling a matter, Sancheti Products. The corporate debtor is settling with Phoenix. What should I say? And Justice Mantha, your lordship has seen, they said after settlement, the sale was infructuous. So I receive a sale certificate on the basis of an infructuous sale. And the case cited is, if a sale is made by public auction, doesn't need registration. One doesn't have to go that far. If the court has said the sale is infructuous, what sale is there? Justice Mantha has said, in no uncertain terms, the sale has become infructuous because the parties are settled. SBI gave its loan to Phoenix, who settled with Sancheti. After that, what remains? How can I get the property then? If there are any settlements, intersays, SBI and Phoenix, they can make that. But the money has come. Otherwise, the Chief Justice Division Bench would have said no. Because of suppression, why should I direct SBI to put in the money?
And Mr. Mitra, what is your reply to the argument of Mr. Shaha that the sale certificate is a conclusive proof that sale has taken place? So after that, whether you have that option?
No, I had filed my writ petition before. Kindly see the first writ petition, when was it filed? In 91. In 21, sorry. WPO 199 of 21 was. In 21, assignment was in. The sale certificate was issued on 28/3/22. So much after this. Sale certificate, and kindly see that, I don't want to throw stones, but kindly see the sale certificate once at page 14. It is for your lordship. At the top,
can we reopen that?
Sent from Ritesh Samant, 2nd June 22. And what is he sending? Sale certificate of 28 March. Lord, I don't need to say anything more. Some things are best said, left unsaid.
Left unsaid, yes.
Some things are best left unsaid. I will say this is best left unsaid. Just the top.
Mr. Mitra, just put in a short written notes of
If
argument.
the lordship desires by Monday.
Because they have put in something.
Yes, I understand, my lord. There must be equibalence.
Equity should be there.
Yes. When we enter the High Court, we see the justice is blind and both the scales are together.
So we have to be on braille. And your written notes of our. Very well. Here, oral arguments are concluded. Full stop. The petitioners shall put in their short written notes of argument on June 30, 2023, when the matter shall next be listed. Can you do it on Friday? I mean, it will be a very
Friday, my lord. I'll do Monday. I'll be happy with Monday, my lord.
Monday, very well. June 30 na kore on July 4, 2023.
Yes.
Monday will be the combined list otherwise. So
July
I'm
4.
putting it on July 4th.
I'm grateful to your lordship.
Thank you.
Otherwise, I will be happy and that I have submitted something which is worth your lordship. You will digest. Your lordship will not say, what is this coming? Just because I say anything, they will write. I don't want that comment at this stage of my career.
On 4th, Mr. Joy Saab will not hear.
It's between me. I will just hand over. I will not say anything.
He only hand over.
Just give an email copy to them also.
Yes.
They'll give an. Do you have handed over your copy to them?
Yes.
So please give an email copy to them.
He's handed over list of dates. I already given. I can give my list of dates to them also. I have given. Oh, his argument is list of dates and that case of that registration.
Rather, they have not supplied their list of dates to us.
Not supplied.
Not supplied.
Put it in the note. I'll put it in the note and give it to him so he can have the list of dates.
They will file and they.
No, list of dates. What your lordship will.
At the time of hearing, they file list of dates.
Also, yes.
But they did not supply us.
Should be given to you.
List of dates is what your but they are given. This is not Bible to your lordship. Your lordship will see
No,
for your lordship.
This is fact. This is fact. You should admit. Your junior.
You should also admit what you said in the appeal court. He said this is a final hearing and arguments were made is prima facie if you do not accept it. No. Kindly see. May I read it?
Again, you are start hearing.
No. I will start. I've said nothing.
supposed to give
I've just
reply
shown
to
the
this.
tip. I've just shown the tip of the this thing, sales certificate.